You never know. Second item agenda would be to see if there's any public comment by anybody at this point in time. Hearing or seeing none, we will move on to my oral report. Again, remind you to speak up on camera. And I'd like to make some introductions going around the table for some of you. We'll start to my right because he does. Most of you know him, but he doesn't appear all the time in person. We have Patrick Krill, who's our consultant, and he'll be speaking more. Down to the left, we have Richard. And Richard, your capacity here is?
I'm a senior program analyst with the Office of Research and Institutional Accountability in the San Francisco Office of the Bar, working on the appendix I review in its entirety.
Great. And then next to Richard is Shelley. Shelley, could you explain your position here?
Sure. My name is Shelley Fraser, and I am the newest clinical rehabilitation coordinator with the Lawyer Assistance Program.
Great. And then another guest we have here is Judge. Could you introduce yourself and wave to the camera kind of backwards?
Good morning. My name is Yvette Rowland. I'm a judge with the hearing department in the State Bar Court, and I sit in Los Angeles.
And always thank you for your participation.
Thank you.
And then Donna, just because you were with the State Bar.
Yes, Donna Hershkowitz, Chief Programs Officer for the State Bar.
Thank you very much. We have some consent items to deal with. Approval of the minutes from March 3rd, 2018. I'll give you a second to review them, and then I would need a motion for approval. So moved.
Second.
Seeing no discussion or edits, all those in favor of approving the minutes, say aye.
Aye.
Opposed? Passes. Minutes of the 2018 March 3rd are approved. Now we need to review the minutes of March 20th, 2018. Give you a moment to review those. Do I have a motion to approve?
Wasn't present at that meeting, so can't approve.
That's right.
Motion. So moved.
We have a motion to approve by Andy Besser. Do I have a second?
Second.
All those in favor say aye.
Aye.
Passes. I just want to also recognize the Purcell who just walked in as a guest. Thank you very much, Ken. Always appreciate your work.
Thank you, Michael.
No. And just so you know, we're live cast,
Yes.
and they are asking us to speak louder than normal.
Okay, thank you.
And that the microphone is very sensitive, so sidebar conversations can be picked up.
Oh, okay, very good, thank you.
Moving right along. Staff reports. Turn it over to Michelle.
Okay. Well, part of my staffing update is to introduce Shelley. You've just met her briefly, but she did not brag about herself. So I will just tell you that she has been a wonderful addition to our team, and she's been taking up the job so quickly. I sent out for the committee members who received an email about her when we hired her on full-time, but she had been a temp for a few months before being hired full-time, so she was, jumped right in and knew the role already. And one of the things, I don't know if I put on there, is that she also had some teaching experience in the Graduate School of Social Work at USC, and we've already been able to take advantage of those skills because she planned a motivational interviewing training with the Office of Probation, of which we got fantastic feedback on. So, very happy you guys get to meet her in person. Also regarding staffing, I don't know if everybody had heard the update that I'm officially in the program supervisor role, because I think that happened since the last meeting that we had. So all of our clinical positions are filled now. The only vacant position that we still have is the outreach person, who is now a senior analyst position. And that's already been posted in recruiting, and we're going to do interviews. So fingers crossed. I know it didn't work out so smoothly last time, but by the next time we meet, I am confident that I'll be able to either tell you about or actually introduce you to the person who will be in that position. And let's see, that is all the staffing. And Shelby, a lot of you met Shelby because she came here to some of our meetings. Shelby came, so she has finished her contract with us, and so she is studying for the bar now full-time. So that's why she is not here. And so the new senior analyst person who we take on will be taking over some of those projects that Shelby was working on. That's all I have for staffing. Questions, concerns? The clinical review process, the next item. We've been rolling out the clinical review, so this is to follow up on what we were talking about at the last couple of meetings about replacing the evaluation committee process with this clinical review process. And it's been going very well so far. We've gotten good feedback. The clinical review team has been myself, all of the clinical rehabilitation coordinators have actually all been able to make it to all of the meetings so far, the group facilitators, and the participants. And the participants have really liked the flexibility because now they're not required to be here in person. So some have elected to still come to the office in person, and most of them have elected to be present by phone or not at all if they feel confident that it's just pretty much a done deal. They already know what's going to happen at that meeting. And so I think people have been really appreciative of that flexibility. And we've been able to be very efficient because we've been able to make, to do similar kinds of determinations as we were doing with the evaluation committee, same quality, but of course, financially it's been a savings because we haven't been paying for the catering and the travel for the meetings, and time-wise it's been a saver for the staff too. So we've been able to do 2 clinical review team meetings a month so far for the past 2 months, and review as many cases as we work with the evaluation committees. And so that's also, the last point about that is, it's eliminated our backlog too. I don't know if you remember the problem we had sometimes that our paperwork said that people would meet with the committee within 60 to 90 days of entry. And that wasn't always happening because we, at one point several years ago, reduced the number of committees we had so many people coming in. And it was with everybody's schedule had to coordinate, the participant had to be able to make it to the office. So it was sometimes 5 months or longer before someone was able to come for their first meeting to be officially admitted to the LAP. And now that's done. Now we've gotten through all of the backlog, and so the people that we're seeing for the next meeting have come in within the past 2.5 months. So I think it's going pretty well. And we'll talk more about that a little bit with one of the agenda items about the ECs and making some changes to our program rules. The next item on here is the recent developments, and I don't have any recent developments. Donna was at the Board of Trustees meeting yesterday, so I believe you have developments.
Yes, thanks, Michelle. Yesterday at the Board of Trustees meeting, we brought forward the item that we all had discussed at our March 3rd meeting about the transfer policy for excess LAP funds that were not necessary, that were sort of in excess of what was necessary to sufficiently and fully fund the program. I presented the policy that the committee recommended, which was a sort of a 2-pronged policy. It was a sort of basic formula of how you would calculate the the excess with a requirement that in determining the amount of budget that we should allocate for program growth and enhancement and improvement, that there would be a conversation as part of the annual budget process. There'd be a conversation between the committee, the oversight committee, and the changed it to the chief executive officer. We had looked at it as the chief financial officer, and so that policy was adopted. The second piece of it was the committee. This committee had recommended that irrespective of the policy not be implemented until after December 31, 2020, in light of the various uncertainties that are out there. And I explained those to the board. The uncertainties included the fact that we don't know what the cost of a fully utilized LAP will be. The uncertainties include the potential loss of just under $200,000 of annual revenue. If the statutory proposal is enacted, that would redirect $1 of every $10 assessment that currently goes to LAP to a nonprofit that provides substance use peer counseling to lawyers. And also the uncertainty of Appendix I and what that outcome is going to be, and if there is going to be a separate entity, what those kinds of startup costs would be. And so the board took into account those uncertainties, but they also took into account some of the feedback that they received from the legislature with regard to the proposals that the various options that the board had submitted with regard to how to provide additional funding to the Client Security Fund. There was a list of options, and some of those options included redirecting internal funds such as the excess LAP funds. Other options included reducing the number of people who would be eligible for reimbursement by the Client Security Fund for financial losses that were due to misconduct of their attorneys, or further limiting the amount of money that those individuals might be eligible for. The legislature expressed in their analysis of the State Bar's annual fee bill, the legislature expressed uncertainty, expressed that they were not that they did not favor the options that would reduce the amount of money that an applicant for the Client Security Fund would have access to. It did not favor options that would reduce the people who would be eligible for Client Security Fund reimbursement, and suggested that the bar focus on the options for finding internal funds in order to support the Client Security Fund. And so with that background, with the understanding of the needs of the Client Security Fund as well, the board acted to transfer a small amount of LAP funds this year, and that was $250,000 that they directed that be transferred from LAP to the Client Security Fund.
Any comments on this? Does everybody understand what happened? Great.
So,
Go ahead, Ellie.
just one quick, so when they made the comment that they wanted to make sure that there was enough money for, I don't know if the word victim is appropriate or, of what had happened. So is there lacking money? So when they chose that figure, how was that figure chosen then?
Yeah, so the board issued a report to the legislature on March 15th about the health of the Client Security Fund. The Client Security Fund has a significant shortfall. The report that we put together identified a significant one-time shortfall. I think the number was about $23 million. And then a small ongoing shortfall. Client Security Fund, like LAP, is funded by a certain assessment from the annual fees that lawyers pay. For the Client Security Fund, it's $40 per lawyer. And so on an ongoing basis, what was identified was if there was an additional $10 bump for the client security fund from $40 to $50, they'd be able to handle cases in a timely manner. Right now, it takes, the average is about 36 months from when you apply to the client security fund. When you're eligible, I believe, for when you would be eligible for payout, i.e. after discipline has been meted out against the attorney before that reimbursement happens. There's a significant backlog of cases right now, and that's attributable to an significant influx of applications as a result of the mortgage crisis and the less than reputable practices that were happening by some lawyers at that time. And so you had lawyers who were harming not one person, not 2 clients, but 1,000 clients. And so there really was quite an uptick. The Client Security Fund went from an average of 845 applicants every year to topped out at about 3,800. And so we're working through that backlog and trying to get down, but there's been a huge concern by the bar, by the legislature, about the amount of time it takes in order for people to get payouts for the harm that was suffered at the hands of their attorneys.
And what's the maximum amount they can be paid out?
The maximum amount that could be paid out is $100,000. The average amount that's paid out is $7,043. And so a $250,000 transfer of funds equates to about, I think it was about 35 additional people that might be able to be paid out this year. They also transferred, there was a significant reserve, based on some formula issues, there was a reserve that CSF itself held, and they transferred $1.5 million out of that reserve into their active budget. And they had transferred previously, I think, $800,000 out of their reserve into their active budget. So they'll be using all of those funds and going from their annual roughly $6 million that they have to pay out to clients will be going up to more like $8.5 million this year, and that will provide some support. It won't eliminate the backlog of the amounts, but it's for this very reason about the significant time it takes to pay out the applicants to the Client Security Fund, that the legislature adopted the language, the statutory language that authorizes the transfer of LAP funds to support the Client Security Fund. So there was no magic, Kelly, to answer your question, there was no magic to the $250,000. It felt like an amount that the LAP could absorb, but not so significant that it would limit the ability of LAP to go forward with the program enhancements and improvements that we're seeking to do. The board did, so without having to actually say this out loud, but they did out loud, basically reserve the right to come back and have a follow-up conversation about this after the Appendix I review decisions are made, because if LAP continues to be fully functioning within the bar, then planning for those startup costs would not be necessary. And so the board might want to consider at that time whether there are additional resources to redirect to the Client Security Fund.
I had a question, I heard you say that there's an idea to increase the $40 assessment to the members of the state bar to $50.
There's a need to do that, but it's not being pursued right now.
Okay, and so that's what I want clarification. And has there been a discussion about increasing our state bar fees?
There have been many discussions about increasing the annual licensing fee. Unfortunately, there is not currently an appetite in the legislature to increase the fee this year. We're in significant discussions about increasing the fee through next year's legislation, so that would be the fee for 2020. But there's no interest in increasing the fee this year. We did have a lot of conversations about it. The bar is deficit spending. It's not something that can continue. We don't have funding to support necessary IT projects, and so we're operating on a fee that went in place 20 years ago. And as everybody knows, there have been a lot of cost increases in that time. And so we absolutely need a fee increase. We've had a lot of conversations about it. There just wasn't the political will this year to make it happen.
As a point of information, what is the fee? What is the yearly fee at this time?
So the base fee is $315, and then when you add on for the client security fund and the various assessments, if you don't take deductions for the lobbying fee or legal services, et cetera, it's $430. And I think it's $155 for inactive.
Or inactive?
Yeah. That I'm not as certain of that number, but for the active, I am certain.
Any other, yes, Justin?
Did the board discuss additional transfers of funds before the Appendix I review
No.
would be complete? So
No.
$250,000 is basically what what's going to be taken from our fund until the future of LAP is decided?
Yeah, there was no indication that they would be revisiting that issue in between now and when the Appendix I is done. It specifically talked about reserving the right to come back after the Appendix I decision was made, but there was no discussion of doing that before that.
Any other discussion, comment? Okay, moving right along. Are you any more recent developments?
Nope, no
Donna?
other recent developments.
Unless folks wanted to talk about oh no, that's on the agenda. So, no, we're good.
Great. Moving right along, item 4, business. A, participant eligibility for financial assistance.
So I'll start with this. This, I suppose we haven't talked about this yet. Business and Professions Code 6235, as you read on the top here, establishes our financial assistance program. And it has the wording in there to ensure that no member is denied acceptance into the program solely due to the lack of ability to pay. And likely because of the reference to member, but regardless of the reason, State Bar Rule 3.252 limits the eligibility of financial assistance to only active attorneys and inactive attorneys. And it prohibits attorneys who have been disbarred or resigned, or law students or bar applicants whom we are now serving. So populations who are not able to apply for financial assistance, law students and applicants, of course, who often are the ones who are telling us that they can't afford to pay for the program, and disbarred attorneys who are often also the ones telling us they can't afford to pay for the program. So this agenda item is to propose an amendment to Rule 3.252 so that we can expand the eligibility for financial assistance, which would require first sending out this proposal for public comment, and then eventually an amendment to Business and Professions Code 6235 to clarify the eligibility. So on page, doesn't have a page number, but after this agenda item, in the attachments, you will see attachment 8A has Business and Professions Code 6235, the way it's worded, and then the amendment just changing the word member to person eligible for services. Here's the LAP. And then attachment B are the rules as they are written, and attachment,
It's Derek, I can see.
C.
He has multiple pages, so you have to.
okay. Changes Rule 3.252. Of course, the wording active or inactive California attorney, because that's been a far-wide change from the wording of member to licensee or attorney, and then adding candidate for admission, former attorney or candidate for admission may be eligible for financial assistance in the form of a loan.
And candidate for admission is defined elsewhere in the rules as a law student or somebody who is applying to the bar. Yeah.
For clarity, does it need to be defined in that?
No, because it's defined in a definitional section. We use that term candidate for admission throughout the 6 pages of the LAP rules. So I think it would be more confusing to define it again here.
Right, thank you.
So page 3 shows our staff recommendation about the motion to be recommending to the Regulation and Discipline Committee to circulate for public comments these amendments. And eventually the amendments to Business and Professions Code.
Michelle?
Yes.
The process, just assume we approve the recommendation, pass it on to the Board of Trustees. What's the timing on all of this?
Oh, I don't know what the time frame would be, when they'd be able to pick it up.
So the Regulation and Discipline Committee is next scheduled to meet, let's see, this is May. They are next scheduled to meet in July. We typically ask for approval to go out for 45-day public comment, could be as long as 60. I imagine this would make sense to do 45-day public comment. And then the committee, the Oversight Committee would meet and review the comments that were received and see if any changes to the rule are necessary, and then propose to the board adoption of the revision of the rule at the board meeting that would be in, let's see, this goes to Brad in July, 45-day public comment. You may or may not be able to get it on the September board meeting. If not, it would go to the November board meeting, adopted by the board in November, effective immediately for that rule change. And we could also, concurrently pursue the legislative change, so have that done through this legislative session.
So, and then that's another point, so we get it through, and then we have the legislative change, and that's a whole new game.
Right, and since there's a lot of cleanup that's going on right now with the statute, so as Michelle referenced, we're throughout the bar sort of making sure to change references from member to attorney or licensee. We're changing references from dues to fees as part of the separation of the sections from the bar, and the focus of the bar as a regulatory agency and not a trade association. And so those kinds of cleanup amendments are part of the fee bill. And so we are there is in fact language to amend 6235 already to change the reference from member to licensee. So we would actually have an opportunity to get in now while that's moving forward, and have this person eligible instead of licensee be put in now, hopefully. So it would be that change would be effective January 1.
So I just wanted everybody to know that this is a real fast process. And it takes some time. What we recommend the board and what legislature does are entirely different. So, okay, we have to have a motion on this, don't we?
Yes.
So any further discussion on these changes? Do I have a motion to recommend the changes before us? So moved. I have a second. Yes, we have a second. Do we have any discussion on this? Okay, I'll call for the question. All those in favor say aye.
Aye.
Opposed? Okay, then we approve the recommendation stated. Michelle?
Okay. The next item is the proposed rule amendment reflecting the elimination of the evaluation committees. So this is what I was referring to earlier when we were talking about the clinical review team process. So in the rules, I could read what the background is, but I think you all know that the evaluation committee was replaced by a clinical review team, making similar recommendations the evaluation committee did previously. And in several of the state bar rules, 3.242, 3.246, 3.249, 3.250, there are references to the evaluation committee. So this proposal is to amend those specific rules as in attachment B of this agenda item in order to change the terminology evaluation committee to lapse clinical review team. So in rule 3.242, the duties of the oversight committee, it strikes out C, which is establishing the evaluation committees. And then for the rules following where there's a reference to evaluation committee, changes it to lapse clinical review team.
For
So-
some, go ahead.
So similar recommendation to the Regulation and Discipline Committee to circulate this change for public comment. That's what the motion would be, to recommend public comment for that.
My point of information is, so this, when we're saying lapsed clinical review team, are we addressing the issue that we want a clinical person on the, going forward?
Yes, because we had, the terminology, of course, of clinical review team, and in the previous agenda item from the May meeting, we had redefined that as having a licensed clinician, and that I don't remember the exact wording, I don't have it in front of me, that the opinion of the licensed clinician would supersede the opinion of other staff who might not be licensed clinicians, and in the case there's no licensed clinician, then we would contract with a licensed clinician to be involved with those clinical review meetings.
And wasn't there also the discussion that if, and it's not from now, but if even the supervisor were a non-licensed clinician, the clinician would, their opinion would prevail?
Yes,
But that isn't the case now, anyway, but for going to the future.
correct.
Is that contained in here also?
The wording had, remember if it said specifically if the supervisor was?
Yeah, so
non-licensed?
the wording for the clinical review policy that was adopted at the March meeting was very specific, that if the supervisor wasn't a clinician, then, or it said, I think it said if either the clinical review
Right.
coordinator or the supervisor wasn't a clinician, the perspective of the clinician would be overriding. And so since the policy lays that out, this is just sort of putting the words clinical review team in lieu of where it said evaluation committee, but the policy is the overriding direction of how the clinical review team operates.
Then that would be as we discussed.
Judges, are you satisfied with that?
I think that what we discussed last time.
Are these changes just for the, they're not for the individuals who are referred by discipline?
It's for all LAP participants, monitored participants.
And then, do we define clinician? Do we have that somewhere? What we mean by that?
I believe it says licensed clinician, I don't know, it wasn't in the amendment,
Should we define it?
in that previous agenda item, in the policy manual in our policy and operations, we defined it as licensed clinician in terms of mental
Just in terms
health,
of having,
not
like,
a physical therapist or something.
That's what I'm just raising one, because sometimes people say I'm a clinician, but they're not licensed and they don't, but they just call themselves that.
Yeah, we specifically say licensed clinician,
No, it doesn't.
but like Michelle says, that we certainly didn't intend to include physical therapists. So I think you're right, the policy, the LAP policy operations manual would be the right place to do that, to make sure that we have a common understanding.
Okay, great. Any other discussion? Hearing none, or seeing none, we would need a motion to approve the recommendation for this book review.
So moved.
Second. All those in favor say aye.
Aye.
Opposed? One opposition. Okay, it passes. Moving right along.
So the next topic is the state bar legislative priorities.
No,
Oh, no, I'm sorry. That's my next agenda item. for the
That's
next
your
topic.
next.
Yes, it's not my agenda item. Okay.
So we're going to turn it over to Patrick, and Patrick, we are live, and you're so well dressed up, and I'm in my aloha. Would appreciate to start out maybe a little bit of a definition of what we're talking about in Appendix I.
Sure, the appendix I review is a review that's happening more broadly within the state bar. Richard actually might be able to sort of speak to, he's overseeing the broader review, so I wouldn't want to misspeak about its sort of dimensions and where it stands in terms of progress.
Yeah, so briefly, the Governance and the Public Interest Task Force noted that there were some 12 additional sub-entities for which review was needed to examine them through the same lens that had already been done and used to separate the sections from the bar, which is to say, to look at their functions and see for each of these sub-entities, were they an appropriate function for a regulatory agency, aka the bar? And if so, what was the best way to carry out their function? Was it staff? Did they need a committee? If they needed a committee, what kind of committee? What should the division of labor be between the committee and the staff doing that substantive work in support of that function? And so, excuse me, across all of these, those kind of global questions are being asked. And then within each, the board had identified, or the task force had identified some the questions that occurred to them as they posed those bigger questions for each sub-entity. And for this one, it included the fundamental question: is it something that should be done within the bar, or is it better done outside the bar for the reasons, some of which Patrick touched on in his earlier report about concerns that participants might have about confidentiality or program effectiveness or whatever they might be. So I think that's the framework for this. That report is due to go to the board at the September meeting. Between now and then, there'll be a process of consultation with committees, staff to committees, drafting and so forth to try to ensure that, first of all, there's an accurate description of what the sub-entity does, because there seems to be, in some cases, some unevenness about that. And secondly, then, getting the perspective of those doing the work currently on how it should be done, and then evaluating all of that information and keying up recommendations for consideration by the board.
Right. Great. Thank you, Richard. That's for everyone's understanding, the broader context of the Appendix I review that is ongoing, specifically related to the LAP and whether it is properly situated within the state bar. That's the work that I have been engaged with, conducting an analysis and working towards a report which will be submitted to the state bar in June, just sort of with my findings as it relates to this question of whether the State Bar of California is the appropriate or best host for a lawyer assistance program, given some reasons which are articulated in that Appendix I question. So what I wanted to share with you this morning were my initial thoughts related to that analysis, and to read from you some of the sort of draft notes from my report. And so I'll start there, and this may take about 20 minutes for me to get through what I have to share, and then my hope or my thought is that we could then have a discussion. I would like to hear from the Oversight Committee members. I would like you to sort of share not only your impressions of what you've heard from me, but also your own thoughts that you bring to this. So I think it's important to note that this question of whether the LAP, whether the State Bar rather is the best host for the LAP is, it's not something that can be analyzed in a vacuum. I think it's important to understand the broader landscape as it relates to attorney health and well-being, not only in the state of California, but nationally, because I think that really does help us to just sort of frame the discussion. So in taking that broader context into consideration, substance abuse, mental health, and lawyer well-being generally are becoming increasingly important priorities for the legal profession. Following the publication of 2 studies in 2016, one about practicing lawyers published in the Journal of Addiction Medicine, and one about law students published in the Journal of Legal Education, a national task force on lawyer well-being was formed in response to what are clearly troubling levels of substance use and mental health disorders in the legal profession. The task force, of which I am a member, then published a comprehensive report titled The Path to Lawyer Wellbeing, Practical Recommendations for Positive Change in August of 2017. That report contained recommendations for all stakeholders in the profession, including lawyer assistance programs and bar associations, to begin to address behavioral health problems in the profession more proactively and with greater commitment. Subsequently, the American Bar Association passed Resolution 105 in February of this year, urging all stakeholders, including state bar associations, to adopt the task force recommendations within their states as appropriate and to work to reduce the prevalence of substance use and mental health disorders in the profession. Since that time, a total of 17 states have already formed their own statewide well-being task forces, and several others are in the exploratory and planning stages. It is important to note these statewide well-being task forces are being conceptualized and formed with the state's LAPs as strategic partners who will play a pivotal role in the task force's work. It's my understanding that discussions around such a task force are not currently underway in California. Furthermore, the ABA president formed a working group to improve lawyer well-being, of which I am also a member. Of the many initiatives that group is bringing forward, one that is of particular relevance to this discussion is a law firm pledge to reduce the incidence of substance use and mental health disorders in the legal profession. Likely launching at this year's ABA annual meeting in August, the pledge campaign will ask law firms to become signatories to a 7-point framework to improve the mental health and well-being of their lawyers. One of the 7 steps in that framework specifically states that law firms should seek to partner with lawyer assistance programs and to utilize their resources. Finally, in the realm of law student well-being, student governments at the top 14 law schools in the country, members of the so-called T14, recently banded together and signed a pledge that they would work collaboratively to demand greater access to behavioral health resources in legal education, as well as other structural changes to the profession which would support better mental health. Again, this also points to an important role for organizations like LAPs to play. A number of these schools have recently conducted surveys of their own student populations, including Harvard Law School, and found that the rates of substance abuse and mental health distress, including suicidality, are far higher than previously known. Taken together, the increased focus on lawyer well-being, the increased and growing emphasis on lawyer well-being and law student well-being is quite clear, and also makes this a potentially fraught time to be contemplating existential questions and complex structural changes related to the State Bar's Lawyer Assistance Program. When it comes to the Appendix I separation question, the foregoing facts are not dispositive in favor of one particular course of action, nor should they be viewed as necessarily supporting one outcome over another. Rather, they should inform the conversation more broadly and underscore the importance of a rigorous and transparent analysis and ultimately of reaching the right conclusion. Turning to that analysis more specifically, one of the issues that I've struggled with, and I've had a brief conversation with Donna and Michelle about this, is deciding what standard or evaluative criteria should be applied to the central question we are seeking to resolve. For example, in legal analyses, we have different standards of proof, ranging along a continuum from substantial evidence standard to a preponderance of the evidence standard to a clear and convincing evidence standard to the most famous and also the most stringent standard beyond reasonable doubt. While this is not a legal matter or proceeding, I do believe it is critical to deploy some sort of standard or decisional matrix or framework for analyzing this question as objectively and dispassionately as possible. It is important that individual agendas, personal passions, and biases related to this subject matter and organizational politics be extricated from this process, analysis, and decision to the greatest extent possible. Now, in service of an objective and thorough process, it is my opinion that something known as a SWOT analysis may be a useful construct for us to consider. A SWOT analysis, for anyone unfamiliar with the term, is a strategic planning technique used to help organizations identify the strengths, weaknesses, opportunities, and threats related to a business decision or project planning. We even have an easel here today should we want to draw that grid and sort of facilitate our conversation that way. And we can talk more about that as time allows and perhaps even use that to frame the conversation. What I'd like to turn to now are 2 surveys that have been conducted since the last Oversight Committee meeting, both with an eye towards informing this discussion and helping us make a good decision. One was a survey of national LAP directors. So I put together some questions seeking to understand what LAP directors think generally about the best sort of structure and operating function of the Lawyer Assistance Program. It was disseminated through the ABA COLAP, the American Bar Association's Commission on Lawyer Assistance Program Directors Listserv, and we had a very robust response. We had 37 directors of state bars respond to the survey. One of the questions we asked, obviously, was how their sort of current LAP is structured. The majority of respondents were within the state bar, 38%. 11% were agencies within the court. 24.3% were independent, which we think of as sort of nonprofits. And then 27% were sort of hybrid structures, which I will talk about. I'll elaborate now sort of what those were. One identified as an independent agency supervised by state bar funded lawyer assessments. I believe they mean dues. One is a program of the New York City Bar. One is a State Bar Association committee formed by Supreme Court rule. One is a program of self-insurance of the State Bar but kept confidential from the bar, and a professional liability fund. Another stated that they were a state-funded program within a county bar association, et cetera. So that's just sort of a range of the variety of structures that are out there within this sort of hybrid classification. We also sought to understand how many lawyers these programs are serving so that we knew if we were making an apples-to-apples comparison to the extent possible. Clearly, there's no other state that is, identically situated to California, but there are others that have similar budgets and serve similar levels of lawyers. So we do have a breakdown there, and we also have a breakdown of budgets. There are only 2 other states that responded to this survey that have budgets as large as California's. And they are both state bar programs. One thing to note is that of the states with the largest budgets, none are currently operating as independent or not-for-profit organizations. I asked specifically about which LAP structure holds the most value in their mind. I'll note that the majority of respondents have been doing the work for 7+ years, and then beyond that, many of them have been doing it for 10+ years. So they have at least some experience doing this work that would inform their views. Now, for the most part, the views about which LAP structure is preferable aligned with the structure that they're currently operating in. So that's perhaps not a surprise, and it is consistent with the early sort of telephonic personal interviews. I started this process by reaching out and speaking to people individually to get their feedback, which tended to be a little bit more thorough and arguably candid than what we received through survey response. But I thought it was important to survey a broader swath of lab directors around the country. So, consistent with what I was finding in my telephonic interviews, people basically tend to think that the way their state does it is the best. Where there was divergence, however, it broke in favor of being an independent agency. In other words, there were a handful of labs currently organized as part of the state bar or as part of a court system that view an independent structure as preferable. However, there were no programs currently situated as either independent agencies or sort of hybrid agencies that viewed being part of the state bar or the court as preferable. And all these findings, I should note, will be sort of included in the report that's submitted. So you'll have the opportunity to review all of this a little bit more thoroughly. I just wanted to kind of give you the highlights. Yes?
Of the states that believe that independent might be better, are any of them moving toward becoming independent?
Not currently that I'm aware of, although it was important to note, and I need to follow up with these states individually. We did ask whether states have contemplated a reorganization in the past, and based on the initial, I believe, 11 interviews I conducted, I wasn't hearing that was true, but it turns out of these 37 states that responded, 9 have contemplated reorganization in the past. I need to sort of follow up and see what came of that and what they did with that. There was space in the survey for people to submit narrative comments and sort of additional observations in support of what they identified as being the ideal LAP structure. I'll read a few that were in support of being independent and a few that were in support of being part of the state bar. In support of being independent, and this really will mirror both my report from last year and our previous discussions, A level of independence was cited, right? And a level of independence specifically from political interests of the state bar. I saw that in several comments. Increased autonomy, less bureaucracy, greater privacy / anonymity, and finally, one stated that independent organizations tend to be viewed as more trustworthy. Now, in favor of being part of the state bar, one comment that I saw several times, or some variation of it, was there's no need to worry about sort of fundraising, but also the infrastructure issues such as salary, retirement, 401k, etc. Several people said that the well-being of lawyers and their profession is the responsibility of the state bar. There were comments that reflected many 501c3s tend to find proper funding and again deal with the administrative issues. So that gives you kind of an overview of what we found there. Really, I don't know what I was hoping for, if it was going to sort of push us or push this analysis clearly and persuasively in one direction or another, and it doesn't do that, but I think it does inform the discussion. Now, Stuart and Michelle, and maybe you can sort of weigh in on this now if you want, or after I'm finished speaking. I know that you've both spoken to LAP directors around the country, and you have a sense that on perhaps some level, they're all trying to figure this out themselves, right? You know, sort of to get to the best place, and maybe there isn't really sort of a, there isn't a gold standard, if you will. But if you want to share some insights around that, I don't know, but I think that in many ways, people look to a state like California to lead and to actually provide the answer rather than to be searching for it. So that's one survey that was conducted. The second piece I think that was really critical to understand was how the attorneys themselves in the state of California view these issues more broadly, but also how they would be likely to respond to a possible reorganization or restructuring of the LAP. So State Bar sent out a survey to a random sample of currently licensed California attorneys. We ended up with about 1,300 responses, so a decent sample size. And it was combined with the long-planned needs survey, right? So that was something going back to last year. We were talking about the need to have a needs survey to really measure what the need was and the perceptions of need were. So I'll share some of those findings now. One interesting point was the question of, do you believe that substance use and mental health distress are significant problems in the legal profession? 66% said yes, 7% said no, and 25% said they were unsure. We asked, and this is really good, speaking more to the needs assessment part of the survey. Do you know friends, colleagues, or peers in the profession who struggle with alcohol or drugs? 45% said yes, 37% said no, 15% unsure. Same question, but about mental health. 45% said yes, 36% said no, and 17% said unsure. We asked whether they felt that enough is being done to address substance use and mental health in the legal profession. 16% said yes, 35% said no, and 47% said that they were unsure. Now, turning more specifically to the questions which probe this issue of how an alignment or reorganization, rather, of the LAP might impact this, some of the questions that we asked were whether someone would be likely to seek help from a lawyer's assistance program. In the hypothetical event that you did need help for a substance use or mental health problem, would you seek assistance from the State Bar Lawyer Assistance Program? The majority said they were unsure. More said no than yes. So that's sort of how that broke down. Those who said yes were clearly in the minority. We asked which of the following factors would discourage people from seeking help from the State Bar's Lawyer Assistance Program. And it's many of the sort of usual suspects, if you will. These are issues that we've talked about and contemplated generally, but concerns about privacy or confidentiality was the #1 choice, the most common choice. Potential threat to bar licensure was the second most commonly cited. And then there were concerns about effectiveness, et cetera. But it really is that concerns about privacy that seems to keep, or would keep, most lawyers in the hypothetical event that they needed to get help from utilizing the LAP. Now, the question was, would your view of these factors be different if the LAP was reorganized as an entity completely independent of the state bar? The largest percentage of respondents said a very helpful maybe, right? So it doesn't give us a lot to work with. The second highest percentage said they're unsure or they would need more information, which I think is a good lawyer response, right? Then beyond that, some said yes and less said no. So basically it seems that maybe or I'm not sure was overwhelmingly the most common response, some combination of that. So we don't really have a clear sense whether this would impact, but it doesn't seem, it's not clear that it would greatly increase. Reorganization or restructuring would greatly increase. Now, would your view of those factors, so again, going back to the privacy, the confidentiality, threat to licensure, et cetera, would your view of those factors also discourage you from seeking help from other resources, for example, a private counselor, a self-help group, employee assistance program? And the vast majority said no, which to me suggests that those concerns really are specific to a lawyer assistance program rather than more broadly seeking help for substance use and mental health problems. So those are some of the most, in my view, germane findings from that survey for the purposes of today's discussion. And so that's where we are, and that's where I am in my analysis. Obviously, both the results of the LAP director survey and the California lawyer survey would need to be sort of synthesized and included in this analysis, this report that I'm working on.
I'm going to answer your question with the use of maybe Michelle and I could add a little bit of information regarding the directors that we've spoken to. Now, I've over the years talked to a number of directors, and I will say this emphatically that we are considered the big dog as state bars. They have the most lawyers, they have the most money, and yet they're all surprised how slow we are to react, and how far behind we are. And they are really looking to California making a statement, okay? And so their conversations reflect a lot of what Patrick has brought out, is that they're very vested in their own programs for a variety of reasons. They work there, that's what they know. But they're not adverse to change. And they really want to see how it works for California. And so, we're working on it. So that's been my experience with, and I've talked to directors, probably a good 25 of them across the country over the past couple of recent 2 or 3 years. So that's a significant number. And certainly they're all available at the COLAP meetings we go to. So that statement has not changed. I don't know what your experience is, Michelle.
I recently had the opportunity to be in a room with about 30 lab directors and a couple of clinical directors at the COLAB directors business meeting about, 2 weekends ago. And there's a lot of diversity in the programs. I think, everybody has their problems and everybody's got their different complaints and things wrong with their program. And I kind of had the sense that there was a lot of, we have our problems, I'm glad I don't have your problems. And I'm feeling like, I'm kind of glad I don't have some of their problems. By far of anybody in there, we have, I think they see us as like this overwhelming, huge, like, how do you deal with that? And they're like, I've got one law school in the state. I'm there every orientation at the beginning, and we have office hours on campus. And I'm like, well, we've got almost 50 law schools between the accredited and unaccredited and CalCredited. What they do is not possible for us to do for some of these other groups. So we are much better structured. Our staffing and our funding are much more solid than some of them who are just, they've maybe got one staff person who is in charge of all of these volunteers, and they're trying to train volunteers to reach out, and that is causing its own problems with, people relapsing or doing different nutty things. So we have our issues. I think one of our significant issues is that we are so huge, it's hard to reach all of the people that we have in the state, all of the attorneys and all of the law students who would be eligible. And I agree, we haven't had the national presence. I do get that sense from a lot of the directors, and for those of us who were at CoLab last year, had the experience of people saying, "You still have a program in California?" because nobody knew we were around. And CoLab directors around the country are not our target audience. We're not trying to do our outreach to them, so they're not the people we need to serve. But of course, around the state, I think a lot of attorneys feel the same way. So I definitely think we are having more of a presence on a national scene now. Me being at the past couple of meetings has helped with that, and getting more involved with CoLab and getting just more information from the other states about how they're running their different programs has been interesting and useful to inform, for example, some of the paperwork and some of the like outcome measures that we've started talking about and working on. I asked around a little bit about the within bar nonprofit. Nobody has an answer for that of what's going to be best and what's going to be best for us. That answer doesn't exist. I think we're just going to have to make it up.
It's important to note, thank you both. I think it's important to note, and this has certainly been noted in my previous report from last year and in our prior discussions, however, that many of those LAPs that are funded at a lower level have less staffing and arguably less infrastructure. They're serving more lawyers. Their intake is higher. And so, especially if you compare it to percentage of lawyer population. So there's, I just don't want that to be lost in.
I want to say something about that too, though, because that's also not an apples to apples kind of comparison.
No, not always.
Because we are doing a lot more monitoring than most of the states. And when they say they've got people, this number of people in the program, a lot of them are counting their calls that they have the one phone contact with and referrals like we would consider our transition assistance service. And traditionally when we've been reporting our numbers, we're not recording those people who come through the transition assistance service. I'm pointing to Jennifer because she's the one who administers all of those. So Louisiana did a lot of monitoring. There are a couple of states, but there are some who are saying, we've had a lot of monitoring this year. I think we've had 8 or 10 people, and I'm like, well, that we've got hundreds every year. It's a different animal. So.
But what's very interesting about what you said, though, is that yes, even though we are different, the very thing that the lab person told you about what they were trying to do in the law schools, and actually go to the orientation, were things that we talked about maybe at some level trying to bring in. So it's very interesting that they place priority on that to some degree, and something can be done. Not suggesting office hours, but that orientation thing. I think we've all talked about that in the meeting, how that could be a really vital thing for law students. So that was very interesting. Yes.
So Patrick, go ahead, Kelly.
I was just gonna, thank you, for your introduction. You do such nice work in terms of how you pull stuff together and present it, and give us stuff that you want, and I appreciate that. One's a question and the second's a comment. So I'll do my comment first because it piggybacks on yours. Is that when I was hearing your report, I was like, this report really should also feed the communications and the person that we're hiring. Because through there and some of the questions in our surveys, I think we haven't done marketing of what is a lawyer assistance program, what is the offering. So when they don't know and maybe not sure, part of it is because they don't really know what they're responding to and what we have to offer. And I, especially with our funding, and I know we're looking at other things with our funding, but I think the goal of ours, especially after we get the communications person, is that we set up a program, that we are in every, school, and that we do that. And that it's not an email that goes out that's like, hey, or who can volunteer, that it's a set, true training that, you know, there's adherence to a model of how you're doing the training. So it's not just you have Joe and his kind of monologue and what he thinks and his approach, and then you have Susie and her approach, because then you're going to get different biases and different input, which leads to then not consistent of what is the program. So I think that's a very doable goal with where we're moving, and I think it's one that most people, I think, could probably support. I mean, I know some of our other things, people are like, well, but I think that, would really enhance us. We're on the path, and I think your work would fund that, the communications, and maybe as a goal for, you know, we talk strategic plan, is that we get out into the universities or schools. Sorry.
Well, that is our plan, actually. That's exactly the plan for the position that Michelle is currently recruiting for, is we'll be developing a presentation and visiting all the schools. There are 56 law schools in California. Some of them are online, so we don't have to visit them. But there are 44 that are fixed facility law schools. And so we're developing a plan to get out to all the law schools. In advance of that, on June 21st is an annual meeting of what we call the Law School Assembly. And that's something that our admissions office invites the deans of every law school to. And it's a couple of hours, it's not very long, where we talk about the State Bar's admissions office and mostly sort of the bar exam and the various pieces of the bar exam process and moral character, et cetera, et cetera. So Michelle is actually on the agenda. The one non-admissions office presentation on the agenda is Michelle talking to the law school deans. And not all of them come, but we hope to have, you know, at least 20, 25 deans there, and Michelle will be talking about the lawyer assistance program. Also, we've got a mailing going out to the full bar membership. Our Cal Bar Journal email is going out shortly, and the plan, and I'll remind our communications person of this, was to include Michelle's updated LAP flyer. So at least there's some information that directs people to the website, provides a little bit of information about LAP, because absolutely that's our big issue, is making sure people are aware that we're here, what we do, and how we can provide assistance.
And the new admin packet.
Yes.
I'm sorry, that's never happened before, but this, for the first time, we're gonna have information about the LAP going out in the packet that goes out to everybody who passed the bar exam.
Wow. It sounds as though an integral part of that information should be providing details about how LAP maintains the privacy and the confidentiality of its participants, because it sounds like, based on Patrick's survey, particularly of licensed California attorneys, that there is between the I'm not sure group and the no group, there seems to be a lack of understanding as to the extensive measures that are taken at every level to ensure the participants' privacy and the confidentiality associated.
That's a good idea.
Yeah, and I think we can certainly change some minds with more information, but there are going to be those who will just never believe that if this information, if LAP is part of the state bar, if LAP has that information, sure, they say it's going to be confidential, but they just aren't going to believe it. And so we've got to do what we can to convince every mind we can, but there will certainly be some percentage of people who will never believe that information, no matter how many times we tell them that they have a separate database which doesn't talk to our other databases, will believe that it does.
You would not believe the kinds of conspiracies that people think that the bar gets into. Even if we were separate from the bar, we would get the, well, you say you're separate, but you were together for so long and everybody knows each other, and I bet you're all talking. We'll be able to reach the people we can reach, but there are some people we will not be able to reach.
Exactly.
If only we were as organized as people presume
I
we
know.
are.
We could carry out our sting operations.
So that gets to my question, which is when you were talking about you're either part of the state bar or you're separate, is there not a hybrid model? Because I think and you said it in one of your comments, that people are really looking for from the state bar, you know, the support for, you know, 401k or, you know, the administrative support. Is there not a way, or is there anyone to do that, where you can be separate but have that administrative, the hiring part, the staffing, but still be a separate entity?
I mean, to me, it seems like a solvable problem, but yeah, I think the sort of the specifics, the details of, the mechanics of that would be challenging. In my view, the biggest piece around that stability, it has to do with the funding, right? So if a hybrid model, if there was a way to guarantee adequate and consistent funding, similar to the level that the LAP has historically been funded at, but have it separate, then that might be able to achieve that goal of diminishing this view of it being, too closely aligned with the state bar. The more skeptical lawyers are going to say, well, the money still comes from the state bar; they're still controlled by the state bar. So I think if you do, it's a catch-22, because I think the only way to maintain the adequate level of funding is for that money to somehow flow from assessments, from lawyer fees. I just don't think you can get there through a fundraising operation or an independent. But as long as that money is flowing from lawyer fees, there will be some who view the program as, regardless of what you say, it's still controlled by the state bar. But I think at that point we're sort of talking about percentages. How much can we change? How much can we improve?
So you wanted us to have a kind of an open discussion, right?
I think that.
And what would objectively your desires from this open discussion, so we can get going with a full discussion?
Well, I mean, one possibility would be, if people wanted to identify some of, in your mind, and certainly based on everything you heard, some of the strengths, weaknesses, opportunities, and threats associated with either remaining within the state bar, sort of the status quo, or possibly, being reorganized and restructured as a different type of entity.
Judge.
Patrick, and I don't know that you know this, but this would be a comment I would have. Isn't one of the greatest threats or risks of a spin-off is really a failure of the program financially? Just a complete, the program would fail because of financial inability to proceed. Is that, would you consider that a threat?
I would consider that probably the paramount threat. In my view, if the funding isn't guaranteed, then the whole program could fail, right? So I think that's certainly.
So I'm confusing, because I thought when we talked about we would be separate, we would still have our funding. I just assumed that that's what we all meant, but I'm hearing something different, that, you go off and you don't even have the funding. To me, that's like a non-starter.
And so we do have a model. We've been talking sort of in the past, you've heard us talk about the separation of the sections for the non-lawyers in the room. So that would be, our family law section, our criminal law section, trust and estate section that deal with specific areas of law. The sections used to be part of the bar up until January 1. The sections were funded by voluntary donations on the lawyer's annual assessment. You paid $40 or something like that to join each section that you wanted to join. We've separated from the sections. They were considered the trade association part of the bar, and so they are now a separate nonprofit entity called the California Lawyers Association. The annual lawyer's dues fee statement still has that voluntary payment if you want to join. Now, instead of referring to it as a section, if you want to join the California Lawyers Association, you still check the box that I want to join probate, trust and estates, or family law, or criminal law, or business, et cetera, et cetera. And we entered into an MOU with the California Lawyers Association. All of the money that comes in through that fee statement by people checking off that they want to join the California Lawyers Association and pay the money, that money goes from the state bar to the California Lawyers Association. So there is a model for that.
But that's a voluntary.
Yes.
So versus a mandatory, which is what the LAP is.
Right, and I don't know that there would need to be that there would have to be a distinction. I assume we would be able to continue to keep LAP as the mandatory $10, and again, that would be transferred for the services that LAP provides. Should there be a separate entity?
How many assessments are mandatory? Like the LAP?
So there's the $10 for LAP, $40 for client security fund, $25 for discipline. If someone's doing the math, that would probably help.
Okay.
What?
You said 25 for discipline?
25 for discipline, 40 for client security fund, $10 for LAP. Yeah, that is 75.
So we're at 75.
Yeah, so and then, let's see, then you can opt out of 40 and 45. That gets us to 115. Yeah, so that's it.
Okay,
Those
so
are the-
those, there are three that are mandatory?
Yeah.
Okay, so we kind of do have a model that we could possibly have where the funding continues, because
Right.
that would be the biggest risk.
Right, and then the way that we did it, not on a permanent basis, but on a startup basis, the California Lawyers Association contracted with the State Bar for us to, they basically contracted with the State Bar staff that had been doing the sections work for 12 months and contracted with the bar for the space that the section staff were in for 12 months. So there could be a transition, they could establish themselves, there could be an opportunity for the staff to make some decisions if they wanted to ultimately go work for the California Lawyers Association, or if they wanted to stay as staff to the State Bar, and that would be if the California Lawyers Association wanted them to come over, it would be their choice whether they wanted to do that or stay as State Bar staff, and they would find homes as State Bar staff. But that was also a way to ensure that we've sort of talked about that fear of a gap in service where everything shuts down if we were to create a separate entity. And so again, it's a totally different program. But there is sort of a model for how we have transitioned an entity from part of the bar to a separate nonprofit where there wasn't that gap in service.
Donna, does the $10 fee, I know it's mandatory, does that fully fund LAP, or does the State Bar staff, building, lights, whatever, is that a separate fee to fund?
So historically, LAP expenditures, or I historically is an overbroad statement for the knowledge that I have. But certainly for the last several years, the LAP expenses have been less than the amount of revenue that comes in. We collect about $2.1 million.
On the $10.
On the $10. And out of that, that is what is used to pay for the LAP staff. It is used to pay for State Bar overhead, right? So all of the offices pay a certain amount for, the services of general counsel and HR and IT and things like that.
And we also pay a rental fee for an office space and
Yeah.
the utilities.
So that all comes from that. This year, the projected revenue, the projected expenditures exceed the projected revenue by $110,000.
For LAP?
For LAP. Now that assumes 2 additional full-time staff, senior program analysts, the first of whom Michelle is talking about hoping to have hired shortly. So in fact, we're not going to exceed the revenue because we will have those salary savings at this point. But so historically, and that's how we've built up the reserve, is because the expenditures have been less than that revenue.
So is the theory when you're talking about transition that if LAP were to quote transition, then they would continue to receive that funding, or would there be a goal to transition them out of that funding?
I think we've all been working under the assumption that that $10 revenue stream would continue to flow to the services of a lawyer assistant program wherever it may be housed.
And I think that one, which I think is probably later on the agenda, is that issue about taking $1.
Mm-hmm.
So that's a kind of something we need to be thinking about, but that's a whole other topic to not mix up.
Right.
My one concern would be is if we got put into what's currently been formed, that then we'd be associated, since they're all funded on voluntary goodwill basis, but then someone say, well, hey, they're part of it, they should be transitioned to that, because everyone's always targeting how we get funded. So I just put that out there as a caveat, that we don't get hooked up with them and then say, oh, well, they're like them. Because I think people may choose to fund those for different reasons than why we're in existence.
Any other discussion? Justin, you had your hand up and I never got to recognize you.
I've been thinking about the structure of what an independent program would look like. And one that pops to mind is the structure of the nonprofits that do the criminal appeals for indigent defendants. And so those projects or programs or nonprofits, they are funded through the Court of Appeal, and then they have contracts with the different district courts of appeal. So similarly, kind of piggybacking on what Donna was discussing, is that the state bar would basically have a contract with this independent entity, which would then contract and have an MOU, kind of like the Lawyers Association. But then there was the thought of these 401ks and the benefits of, you know, working for a state entity, being represented, and all those things. In my mind, I guess I'm just thinking, what would the ideal, like if you were going to have the ideal LAP program, maybe the starting point would be, what would the ideal LAP program look like for us? And then if that's within the state bar, then, you know, that's better. And if it's not within the state bar, what would that look like? Because there are definitely problems being within the state bar. You know, bureaucracy, it takes forever to change a rule, whereas if you're in an independent program, you can flip a policy like that, and it's done and you're working. You know, we're not talking about going to law schools 2 years later. We're talking about doing that in August. So I think it might be helpful to think about what would the ideal program look like, and then kind of build from there and figure out whether outside of the bar is better and that fits our ideal, or inside of the bar we can make it work. That's kind of like my question, comment.
These programs you mentioned, Justin, that are contracted with the Court of Appeals, are their employees separate from the state bars?
So I bring it up because my wife works for one of those programs.
Okay.
And so she is an employee of that nonprofit. They have their own retirement program, but they also have volunteers on a panel, and who also get paid through billing back through the Court of Appeal. So there is a process by which they have funding. I mean, they have constant funding for the past, I don't know how many years they've been, you know, there. So that gets funded, and they have staff, and they have their own board of directors that is independent of, you know, the state bar. And, you know, the only thing that for them that's kind of a problem for the staff is whenever they want more money, they have to ask for more money through the legislature, through the Court of Appeal, but that's no different than what we're doing here.
Yeah,
Right.
that's the point I was going to point to, actually. When I was at the Judicial Council, I worked closely with these projects called CAPS. And so their funding their funding is sort of a line item in the Judicial Council budget, and they get allocated a certain amount from the Judicial Council to run their programs. And so similar to, you know, if they need an increase for increased costs, increased staffing needs, increased salaries, it's sort of the same way you would be constrained and are constrained now with the $10 being what funds you. It's sort of the same issue where we would need an increase in that $10 in order to provide increases to LAP. They need an increase in the budget line item for the appellate projects in order to get funding. So there is that issue.
I don't know if there's any delicate way of saying this, but working for the state bar, it's union shop, right? And is it competitive with, like your wife's employment is competitive with, I mean, salary? Because I don't know what staff, especially if we're dealing with clinical people, whether it's competitive and whether we it's a wise thing to do. That's what I'm getting.
And I think that's a bargaining thing that would need to be done regarding the contract that's between the entity and the state bar.
Richard?
I mean, to step back for a second. So the framework of this spending side review is not, just to be clear, it's not downsizing, it's not budget cutting, it's the board has a responsibility to the public, to protect the public in
Right.
the ways that it is saying it is doing. And so therefore, the question it's asking is, if we are saying to the public, we are doing all of these things, how do we ensure that we govern them appropriately, that we know what's going on and that it's being held to the appropriate professional standards? And that goes to these services. It's also a question that comes up with, say, accreditation. Are we accrediting law schools through the current structure in a professional way? There are professional organizations, there are ABA-approved organizations, or other organizations that do that accreditation that other states will contract with to accredit their law schools. So that's really the question is, it's not a question of whether providing this kind of service is a good thing or not. I don't think that's the question. It's really, what's the best way to ensure that if we say we are doing it in your name, the public, that we're actually doing it to the best of our ability and to the best professional standards that are.
Oh, I get that, Rich. We're just concerned with whether going nonprofit that route or the different, and independent, or whatever you want to call it, increases our costs dramatically, or it puts a situation where we can't retain and hire qualified people that we normally have. Maybe Michelle, if we were independent, Michelle and Shelley go, God, I can't live on these salaries, I'm going to go elsewhere, I'm going to go to private practice or something. So that was what I was more driving at. Larry.
So I may be oversimplifying a seemingly very complicated issue, but for me, it kind of boils down to the purpose of what this committee is, and to me, it seems like it's to help attorneys who need it, and try and expand the number of folks we can help, and some of the things that are blocking that are some of the things that are blocking folks from seeking help are concern over privacy, what the relationship with the state bar means, these types of things. And so for me, it boils down to, okay, what pathway is gonna allow this committee and this program to help the most amount of people? And again, that's an oversimplification, but if it means going outside the state bar, I'd be for that. Obviously, having to iron out what that means financially, right? So, I'm trying to kind of, take what Patrick took as well as a comment Donna said, which is, to me, funding is the paramount threat. But if we've determined that these are the things, that are preventing folks from seeking help, and it's because of an affiliation with the state bar, it just seems logical we move away from that. So far as the funding is stable, and so far as we can account for things like salaries and stuff like that, it seems to me that this was formed legislatively, right, through Burton's legislation, SB 479. Is there something legislatively that we can either amend or recommend that would, in fact, speak to Donna's point of, regardless of whether or not LAP is housed within the state bar, it would guarantee that $10 funding coming, or something like that. Now, the concern there is, if it says, okay, the $10 fee will go to a LAP or a program, then being in the industry I'm in, competition was a concern for me. So now all of a sudden you created a marketplace for LAP. And so there may be other competitors or other nonprofit organizations that are going to say, hey, look, there's a pot of state funding now, let's go create a LAP. And then we've inadvertently created this marketplace of competition. So, those are just some thoughts that I had on this.
So when I hear what you say, it gets to Patrick and what we were is we've been making huge changes in our program, or wanting to, or talking about it, and we were in some ways maybe stagnant. That instead of making such a huge decision of go out over, why don't we outline truly what are the services we want to provide? First, let's start with that, the services. Like when we say, okay, we're gonna go out to the schools, well, have we really formulated what that means operationally? And then how we're gonna execute on it, and then what's gonna be needed to execute that? And maybe the best way to do that is in turn, we don't know, because we haven't, so maybe we take this in steps. We first start with what are the true services we really want this organization to go forward with. Then look at, okay, let's start to get those in place while some of this other changes is happening before we make the decision of going out or in. Delay that for a year. Let's get some of these other activities up and running. And then we can reevaluate before we make such a huge decision of going outside. Because I mean, we have some internal, I think, threats, if you want to use that word, in terms of like the dollar, some other things going on. And so we don't bite off too big of a chunk. And then at the same time, we're educating about ourselves better. We're clearly defining what our mission is and our role. We're going out to the community, and we're realigning to help do what you were saying in terms of mission first.
Don, is there, or Michelle, or Richard, is there a political reality we have to come up with a decision quickly, independent, and so that Kelly's comments is really...
So I was thinking the same thing as Kelly was talking. Richard, do you have in front of you, or Patrick, the specific language from Appendix I that is guiding the review of LAP? Because there's general language that guides the review of all of the sub-entities, and then there's specific language as to each sub-entity about particular questions that we're looking at. And the way I know we've been talking about it is that question, the key question goes to sort of where's the proper host? Is the state bar the proper host as a regulatory agency to as Patrick and Richard talked about, to make sure that we are providing the appropriate services to assist these issues? As we've been talking about it, it seems like that question needs to be answered as part of what the board is going to be considering in September. But it may be that I'm sort of remembering the context incorrectly.
In my mind, there was, in my back of my mind, we had to have a decision made before September.
Yeah,
So maybe this conversation that you're bringing up, this point is moot. You know, we got to make a decision.
Well, and so, you know, what do you...
So maybe if we had that,
yeah,
I get what you're going at.
I mean, I think it is really part of, it is part of this, it is the crux of the Appendix I question, I think, is sort of, is LAP appropriately housed in the bar? And so what Patrick, the information that, the report that Patrick is giving, which will, by the way, in its entirety be an attachment to the bar-wide Appendix I report, but Patrick's report will be attached to that, and you all will get an advanced copy of that. The Appendix I report itself will synthesize the information from Patrick's report into the same format as the information about all of the other sub-entities. And what we will be including in that report is, you know, an analysis of the structure of the LAP Oversight Committee, the functions that it performs, whether those functions should be continued to be performed by staff, by the committee, et cetera, as Richard described, and recommendations for changes. And importantly, it will include the committee's impressions and the committee's thoughts. And so one of those discussions that can be included in the report is Kelly's point, which is, you know, maybe we don't have the information yet, right? Maybe we don't know enough just yet to make a decision today about separation, and it is something that the committee should develop a project plan, that we will you know, sort of do these things and be able to come back to the board at this time next year in order to have that discussion. That can certainly be part of it.
And is that a feasible option? So essentially a recommendation to defer the decision?
Well, that we got to find out what the language says, right?
Yeah. Well, and I don't know that the board would be willing to do that, but they want to know. They absolutely want to know what the committee thinks, and if the committee thinks that that is the best approach, then that is information the board should be
considering as they are making the decision on how to act.
Point taken, Judge.
So, I'm talking about what Mary had said, and I did think it was interesting, I talked about a marketplace being created, but if we go to the reason, then what is the genuine reason to leave the state bar? You cited essentially this reason that, people, the confidentiality, all those issues. But how real are they? How many people engage those? What about the things that have been done recently, like changing buildings to provide more confidentiality? What has been done to affect that statistic, and what is that statistic, if that is what's driving the whole situation?
That's my point, yeah.
Well, I don't know that that's what's driving this Appendix I question, right? So the language that was specifically contained there, I don't have it in front of me, was essentially, Richard, were they sort of getting at, does it make sense for a state bar to be offering these types of services?
You mean more generically,
More
as opposed
generically.
to a driving question?
Yeah, it wasn't specifically related to that. That may have been one of the supporting rationale that was.
I'm pulling it up.
Andy?
Yeah, just, it seems to me that, our greatest problem is, utilization, an underutilization. There aren't attorneys, statistically, it's like an insignificant number of attorneys are using the services we provide. And I don't know if the work you've done in talking to other states has given you a sense of what they're doing, where their percentages are better, where they are getting better utilization. And maybe having an understanding of what they are doing might inform us as to what the best post will be. As far as, whatever their best practices are, that, as an independent agency, we can do those things quicker, faster, respond to the needs of the attorneys and the public in a way that's different if we were under the umbrella of a state bar.
That's why I think we need to go to services. We haven't really focused on what are the services we really want to, now that we have attention and ability to make changes, what do we really want to do? I mean,
Well,
they're doing tallies of phone calls that we don't even log, and are we really advertising that? I mean, maybe that's something that we enhance. There's more of a phone consultation avenue that we don't do.
Or maybe the conversion to clinical review committee from EC is gonna word of mouth result in people more freely coming and making use of the services.
I think that one of the issues when you talk about underutilization is that the average attorney, I would think, in California doesn't really know about LAP. They don't know that LAP exists. They don't know about the services that LAP provides. And sure, there might be healthy skepticism about confidentiality and privacy, but before you even can have that type of concern, you have to know that the entity exists. I know that before going on the bench, I was a partner at 2 different law firms, both with offices here in Los Angeles. We never heard of LAP. We didn't even know that it existed. So I think it's interesting when Patrick mentions, for example, that the ABA is engaging in outreach to law firms. And I would think that risk management partners at law firms would be significant. Folks to communicate with, managing partners, in an effort to engage them and better educate the law firms in particular, and certainly in-house counsel as well, about LAP and the services that are offered. And while attorneys might be hesitant to concede that there is a certain measure of privacy that attaches to their participation in LAP here, they might be hesitant to go directly to the law firm. There'd be even greater hesitancy to go directly to the law firm, but having LAP as basically an intermediary would be very helpful. So I would think that type of outreach. I think it's significant, for example, that Michelle mentioned that basically the program is staffed except for the outreach position. I mean, that's key, getting the word out.
I found that language if it would be helpful.
Sure.
So 2 issues, this is reading from the actual Appendix I language. 2 issues emerged in task force discussions. The first centered on whether LAP is appropriately situated within the state bar. The program goal is not in doubt, but the state bar lacks expertise in matters of substance abuse and mental illness, making it an unusual host. Moreover, concerns have been raised that attorneys might be disinclined to seek assistance from the same entity responsible for attorney discipline, a concern that may explain LAP's low attorney participation rate. A review of other state practices also suggested that many jurisdictions had chosen to structure their parallel programs as separate entities from the regulatory body precisely because of these types of concerns. The direct relationship between LAP and the discipline system, particularly as related to the direct diversion role it plays for some attorneys appearing before the state bar court, could be a counter to arguments for separation of the program. This perspective suggests that the state bar has a responsibility to ensure appropriate quality control of the services being provided and can best do so if the LAP is part of the state bar proper. So that's sort of the language there that I think we're really kind of focused in on for purposes of making.
So there really isn't a time functionality language in this, but
the full-
reality
yes.
for the
Yeah.
Board of Trustees.
It's
there
going
is.
in September, yeah. And the other piece, the one sentence following that, additional task force discussion centered on the role of the program statutory oversight committee and the role it plays as related to both board oversight and program integration with the organizational structure. So then the question to be considered, whether LIP should be retained within the state bar, and if so, what the relationship what the relationship there, the word there doesn't make any sense to me, what the relationship should be between the board and the oversight committee to the board and the board its committees. The Regulation and Discipline Committee should develop specific directives to advance the two primary components of the LAP strategic plan, educational program and design.
So you wanted to, you divided this into two issues, right? One was the independence or non-independence. One was
I thought that was the most critical point to get feedback on from this group. Right.
Okay. And so,
Richard has.
oh, I'm sorry, Richard.
That's right. So back to your original question, is there a political reality? I can tell you how it looks from where I sit, and I've only been at the bar a couple of months, and I'm only working on this, so this is my reading of the key leaves and the guidance, people working on this. As I tried to indicate before, the perspective of the board is, hey, we've had all of this, we've had a lot of stuff to govern, and we frankly haven't been governing it all that well in some instances. Some very well, not because of bad intentions on anybody's part or malfeasance or anything like that, just because it's a enormous and unwieldy entity. So the question is, my sense is, will the board be satisfied with an answer like, hey, give us more time? I don't think so, absent some concrete evaluation of some of the actual issues. So, and this is where the use of data, the levels of reporting and so forth, who is being served. I mean, not just, there is a perception of underutilization, but again, we need to ask, well, compared to what? Compared to other states, the percentage of those programs is 20% of the, 10% of the existing membership. The raw numbers themselves aren't meaningful because California is so much bigger than every other state that the solutions it requires are different and the problem it has are different. And so, but if we're serving 1% and other states on average are serving 15%, there has to be some reckoning as to, is that really just a marketing problem, or is it a problem of these structural problems that have been identified? And if so, or maybe it's both, or maybe we don't know yet, and here's the data. So it seems to me any desire to craft a incremental, or we need time, we need a bit more time to specify our approach, needs to be framed pretty concretely to have credibility, I think. And I think another issue, and this was one that Patrick had brought up in his early report as well, which is part of this is, because on one level, we still come back to this question, is this something the bar should be doing as a regulatory body? Whether you're serving 1,000 people or 100,000 people or 10,000 people, that question remains. There's a piece of that constituency that is the discipline-related piece, and this is a notion that's also floating out there. Is, well, maybe the bar retains that piece because it's tied to the regulatory disciplinary function of the bar, and then the voluntary piece is a different thing. And then what would that look like? So that's another question that's actively being floated. And I think
Yeah, so I'll stop there, but.
So what if you did a written analysis to some of those points? Because I think, one, it's apples and oranges, can't do a true comparison. We really need to look at how we're defining utilization. And set out a plan that we have as a commitment that we turn in of what we're going to do for outreach and education. We have talked for years in here, we were going to update the website, we were going to do stuff with Twitter, we were going to, all these things that never happened. So we've never gotten the word out. So who's going to utilize something if they don't know it exists? And so if for us to go and break it off, then we're still in the same pot of how do we get utilization? Are we really doing the right type of services? What does it mean? And then we've got all of the, got to find a new home, got to find out our electric bill, kind of like all this other stuff. So I agree, we want something concrete, and I think we should hold it to ourselves. Let's make a concrete plan. This is what we're going to do, our goals, our milestones for a year, having to do with outreach and education, and say that during that time we will see what the impact, find some way to measure, at least education. Maybe it's not utilization because you need time, but maybe it's education and response, and then another year for increased utilization. While we then say, we'll further evaluate how the program fits in, and there is support because of the regulatory component of it, and put that forward. That's concrete, it's measurable, and we're holding ourselves accountable.
Stuart?
Yes, Judge.
If I took the combined comments of Judge Rowland and Richard, the idea that a lot of people don't know about LAP, and I can echo that myself, as even having been a Superior Court judge in all my years as a lawyer, I never knew about LAP. And then take the combination of, is it that people aren't utilizing it because they care about confidentiality, or are they not utilizing it because they don't know about it? And if they knew about it, I don't know if this statistical base we're dealing with that seem to be attributed more to that people aren't utilizing it because they don't want to because of confidentiality. But what if the truth is they're not utilizing it because they don't know about it?
And that was part of the reason for the survey that we did. We did a random sample of 25,000 California lawyers. And did it sort of bear out?
We did ask whether they knew about the LAP, and it was about 50-50.
Oh,
So it wasn't horrible in terms of, obviously you would want it to be significantly higher than that.
it wasn't horrible. And then what was the percentage that said they wouldn't use it because of confidentiality problems, or did we get to that?
That was I don't have the precise percentage, but that was the most commonly cited reason.
I think with confidentiality, the issue with confidentiality, one of the things that we know is the fact that the Supreme Court has said this is going to be confidential, strictly confidential. I don't think that has been, I hate to say that, marketed. That we haven't marketed what the Supreme Court has said. And for lawyers, you're telling me the Supreme Court of the state of California said this is going to happen?
I wouldn't believe it. I'm a lawyer and I wouldn't believe it.
Well, see?
Because and I actually had a problem a long time ago, and I wouldn't go to the state bar for that very reason, is that there's always an exception. Records are sealed and there's always a way around it, and this is my license. And so I'm gonna get help outside of the licensing agency.
And that's the part that we haven't been,
Go ahead, Michelle.
that's the part that we haven't been addressing, is the reducing the stigma aspect. And even if we expand our program, everyone in the state knows about it, we can't accommodate 30,000 attorneys at a time in our program. So whatever the percentages breakdown, the number of people eligible to the program, the number based on the survey that you worked on of how many people need help, they're not all going to be in our program. But the message is they still need to get help. And the survey showed that people are still willing to get help other places through their EAP or faith-based groups. So there's a lot more work that we can be doing that's helpful to attorneys without having them enrolled in an LAP group.
Phil.
You got to remember the population that you're dealing with. I think we're in a way losing sight of the fact that people that have substance abuse as an issue want to avoid any interface with help.
With what?
With help,
Help.
period. And you got to remember, you have to remember who you're dealing with. Now, it's not, the mental health component to some extent is the same, but it is different. But you have to remember that, we're dealing with a population of people who really, alcoholism and drug abuse is a disease, okay? Number one, a lot of people don't believe it's a disease. That's why we have some of the attitudes we have on the Board of Trustees. But past, and you have that in the minds of a lot of people who are alcoholics and drug addicts. So we have to remember that to begin. Then it's a disease that constantly tells you that you don't have it. So there are a lot of problems. We can make the assumption that people that have a disease need help, and we're probably right. But you can't convince an alcoholic who doesn't want anything to do with recovery that he ought to, oh, by the way, yeah, I'm an alcoholic and I need help. There's a lot of paranoia, as Andy just pointed out. There are all kinds of issues that follow from that. So when you say, well, we have to decide what services, I think it was very well defined. The services we want to provide are services of recovery and therapy and for mental health component and for substance abusers. So I think we know what we want to do. The biggest lack that we have had, as Kelly just pointed out, is outreach. We don't have good outreach. But I think we have to be realistic about what follows from that. We can do the best job that we can with outreach. That doesn't mean we're going to get a lot of people beating down the door to get into the program. I think we have to do everything that we can in order to assure that the people who indeed want help can get help. But following from that,
Yeah, no, I agree, and I wonder what's going on in those states where there's greater utilization.
Yeah.
Like, what are they do? What's not there? It's not magic, but what are they doing to get the word out there so that their utilization is up compared to us? I mean, I think there were some states that was significantly higher.
It's hard to point to one specific thing because the culture within each state is different, right? The culture of the legal profession within each state and the views towards the state bar are different. I mean, there really are some things that I'm not sure you could replicate, but something that is being done in many states to a much greater degree is sort of the law school interface. You're putting the LAP on the radar of people as they're coming into the profession. So there is really that greater awareness there. Attitudes vary towards the state bar irrespective of the LAP. So, for example, you can take state X where utilization of their lawyer assistance program is greater, and it may just be that people view that state bar association differently than they might in California. So it's hard to isolate one or even, I think, a number of things that are really
But this is where I mean by the services is how are they defining utilization? That maybe into motivational interviewing, maybe we're promoting and marketing more of a call and talk to us if you have a topic. I mean, or you want, to make it more like the transition lifestyle. So it's not call because you think you're an alcoholic, call because you're struggling with something. And, we put out what are the top 10 issues that attorneys have, and then we start targeting that. I mean, if we really focus that, get them in the door, all that we could say is utilization, every phone call. I mean, we're not helping ourselves with how we're defining utilization.
Right, and that was one of the things that I did identify, and I believe we discussed this in my report last fall, was really if the LAP could begin to operate more as a referral hub, right? So that lawyers could call and just get the name of a therapist or get the name of an addiction, sort of a vetted program, a trusted resource, and they wouldn't necessarily need to engage with the LAP in any sort of meaningful way that they were providing information that they would fear could come back to harm them. And I think you would see utilization levels spike if the LAP offered that service, right? It's just a way to direct lawyers to trusted, sort of approved resources.
Are you talking about that in lieu of or in addition to what we are,
in addition to?
Yes, in addition to, it's
Step
part of the
care.
program. Yeah, it's part of outreach. It's part of outreach. That's what outreach.
I should mention that another part of this is also trying to look at not just how do other states do this same thing, but how do other professions do this similar or same thing. And there it's pretty interesting because lawyers are different. in a lot of ways, and for some good reasons and for some kind of exceptional reasons that one could wonder about. But for example, in some medical boards, it's a complaint-based process. So a patient, there's a confidential referral by a colleague or a patient saying, hey, Dr. So-and-so seemed to have alcohol in their breath or whatever. There's an evaluation of that complaint to see if it's bona fide or not. And this is all still non-disciplinary at this point. And then there is referral and ability to get that person into a program that's going to rehabilitate them, which leads to a further question of should that person still be practicing while they're in rehab. So that's another bigger question. And that goes to how well these programs are monitored and supervised, which is kind of then goes back to our original point about the bar governance. Are we doing the right thing the right way? And then if that process, then that kind of is the overcoming of the self-referral barrier for some of the people who won't seek help for themselves, which I would say probably most of them. But again, there's other ways that other professions have nothing to do with this at all. They say, you know what, architects, you're on your own. I mean, if you have a drinking problem, we assume you could go find help if you want it, and your loved ones will intervene, or something will happen. And so there's different, so I think it kind of goes back to the beginning question of what are we trying to provide for whom and why, what's the responsibility of the bar?
Well, I'm always looking at
The only issue is outreach right now for us.
Yeah, it's a huge issue. And I was just thinking here, we should market. Outreach. And the reason is because then, if the numbers start coming in and we have 50,000 inquiries, we'd be going bananas. And then we'd be going back to the Board of Trustees and saying, we got 20% of every law school wanting information. I don't know how many students that is. And then we have a huge blip. What are we doing? We don't have enough money. That is factual, if we had that. So I think there's no doubt that getting, or we call it what you're marketing, advertising us out there is the priority. The other thing I think is that we really need to do is try to see the best we can, because they want an answer, it seems like, pretty quick about independent or not.
Yeah, that'll have to be part of the recommendation.
And
That
so-
was the question that was posed.
And
So
so
that'll
this
be
is something,
recommendations.
we've come, and it's been helpful having all these other discussions, but really one of the things to be focused on here is that how do we believe we should be independent or not? And then there's also the issue of a hybrid, okay, which I was, both Larry and but Justin really highlighted very well. And I'm wondering, so we have to have this to them before September, right?
Yeah, so, what's the timeline for presenting the draft report? We should.
Yeah, that's
So
correct.
the rough timeline is between now and the middle of the board meeting in July is to consult, draft, and so on, circulate that stuff, so that at the July board meeting there is a full verbal briefing on all the sub-entities, the questions being posed, the tentative, the preliminary recommendations. So there's sort of a full hearing at that July board meeting, which then will allow finalizing that and delivering it to the board's September meeting, which really means it'll be done in August.
Okay, so
Does
when is
anybody
the
have-
July meeting?
Does anybody have an idea of what the Board of Trustees favors? Does anybody have
Good
any
question.
idea at all? Just out of curiosity.
So I think there are different opinions on the board, and that I think came out some when we were having discussions about client security fund and LAP reserves, but I do think that they are honestly looking for the analysis, the recommendations, the view of the committee, and they're not walking into this review of this report that ultimately will be presented to them in final form in September with preconceived notions. I really, truly, honestly believe that this is an effort of analysis and thought and input and figuring out from that what they're
So,
going to do.
what is management's perspective on this, being executive committee and the executive officers of the state bar? Do they have a predisposition one way or the other?
We do what the board tells us to do.
Well, you know, you can always influence. That's a great political answer, but, I mean, is it?
I mean, I think broadly, my sense as a new guy walking into this, I'm not a lawyer, so, is, you know, look, I don't think it's a secret to say that, you know, over the last period of years, the legislature's had concerns about how the bar has managed itself. But, you know, self-regulating professions are a curious thing, and so there's some interest in seeing, you know, okay, we believe you that you are now setting out to write some of this and correct some of it. You've already done a bunch of that. So show me that you're continuing to do that and to be accountable to not just the public, but to us in terms of how you are governing. Don't just say trust us. Don't just say, you know, we're good. Don't just say we need more money. Tell me what you're doing to achieve real governance. And I have to say, there, you know, I think the bar is doing some great things. I don't think they're necessarily getting all the credit for what they're doing yet. Hopefully they will, because whether that's the Client Security Fund or this or something else. And so I think the perspective is we have to demonstrate some progress, some real engagement. And I agree with Donna's perspective. I'm not getting any, we have to cut 20% or you have to get rid of 6 of the 12, or I'm not a hired gun in that sense. My job is to try to gather information and tee it up to make the best possible recommendations for the board to consider and modify and adopt. So it's true, they really are agnostic about some of this. Partly it's also a question of really getting real information about what these entities are doing. There's folklore about all of them. You know, this one does this one does that, this one doesn't do anything, this one's overworked. You know, there's all that usual organizational stuff. So partly it's trying to cut through all of that and be very concrete and objective about what they're doing and why, and whether that's what we should be doing.
And that's part of the reason for this review, is this feeling that the board may not have been exercising the right level of oversight and engagement with a number of these committees and commissions, and wanting to understand what not just the role of the committee and the commission and the program is, but what the appropriate level of board engagement should be. And so there may not be sort of these preconceived notions necessarily, because they may not have been engaged enough in sort of the day-to-day goings-on to have formulated that opinion.
Yes, Judge.
One of the things that strikes me about the timing of it is that, I mean, I guess I would call it maybe a little unfortunate in the sense that we haven't even, the LAP hasn't even really been piloted yet, the law school issue. So we're talking about, let's say that you did a 5-school pilot, you went in, it's still too late, you went in August, you went to the orientation, and it was massive interest, or, you know, so that, that's an unknown, unfortunately, about, and would that make a difference if you put a pilot out, which we see as one of the critical areas based on Patrick's study and other things, being younger people having the problem earlier in life, which ultimately results in lots of problems later. But what would it be if there were a whole lot of interest, if there was an enormous amount of interest in the law schools, and it ramped up the work of LAP so much? Would you want to know that? I'm not saying you're going to be able to delay anything, but would that be a factor in deciding whether you could spin off, and would it be the right time to spin off that whole kind of issue? I mean, that's a little bit what Kelly's talking about, but this is, the law school thing is a really big piece.
I think it's huge. I agree with you, and
I know that's where Kelly's going with. I'm just looking at the political realities of what they are expecting.
Yes.
But I think we do say that the things that we've done are relocate the offices. We've modified the intake process for voluntary participants. That we have gotten approval and structured new hires for specific tasks. That We're yet to see the fruits of these changes, that we expect that they're going to be successful. As Kelly has suggested, that we essentially say, you know, it's going to take a couple of years. There's a year of metrics to monitor with regard to implementations, and then there's another year to monitor for improvement in participants or utilization. I mean, to move outside of the bar, as much as I have identified constraints in the bar, that last meeting I was at, I think I said, you know, it's a sort of game over, that the structure of the positions doesn't even call for licenses. So there are things that aren't ideal here, but if we went outside the oversight of an external vendor, being nonprofit doesn't mean, you know, you're operating for the benefit of, you know, the public and the bar. That's a structure that, you know, is abused regularly. I just don't see us, I mean, that in and of itself is a substantial endeavor.
Right.
Could I?
Go ahead, Patrick.
So going back to what Richard was saying in terms of his sense about, you know, that the state bar would like to demonstrate that improvements are being made and that sort of, you know, effective work is being undertaken. I'm just curious, does that mean then that would a separation be viewed as sort of a concrete and, you know, demonstration that improvements are being made, or would retention within the state bar with a list of things that have been undertaken in, you know, the last 18 months, the fruits of which have yet to be realized, would that be sort of sufficient to say, look, this is what we're doing that is actually, you know, useful and good?
Yeah, I mean, I don't think either one in and of themselves are going to be. I think it's a question of, as you indicated before, there's not a panacea. There's not a one better model that is obvious from you look around the U.S. and other jurisdictions. So, you know, you can have a great structure if it's poorly managed and performed poorly. You can have a suboptimal structure. It's got great visionary leadership and that overcomes all of its challenges and performance, despite how clumsy its structure might be. So I think it's going to be trying to really specify the grasp of the issues in a kind of concrete, empirical way and suggest concrete strategies for how they're going to be evaluated, what metrics would be used, and so forth, if that's the case.
The other thing, and this last thing I said, I don't want to dominate the conversation, is that we've been framing this in terms of, you know, is the state bar the appropriate host for the lawyer assistance program, because that's how the Appendix I language reads, but there hasn't been much discussion about whose duty is it to provide these services, right? So does the state bar, I would say that's a separate way of looking at it, is does the state bar have an obligation to provide these services to the legal profession in light of what we know about the prevalence of substance use and mental health? And if not the state bar, who? You know, so that might be an alternative.
So, which I just wrote a note, but I want to get is why isn't there a task force in the state of California? Which I think that's a separate conversation from your report, where you were saying other states are doing it, but California isn't. You know, I think that's a separate discussion from this, but I think that's an important discussion, and we probably as a committee should have an opinion on where's our role in that. Because that's huge, with us being so large. We don't have a task force, but other states do. But I think it's almost to our detriment if we go outside the state bar right now. The energy of staff to reformulate, then you have to have new policies, new procedures, nonprofit, do you contract, all that. Total distraction from getting back to the fact that we weren't allowed to hire, we weren't able to market. We talked about a separate website, we talked about social media, we talked about, you know, all the things you can do to reach the younger population that's coming in, and that has to be a staff member. We're now going to get a staff person. So I think that you say we finally have the support to do what we've wanted to do, and now we put our energies into what is our communication plan, what is our strategy, what are the venues we're going to do, and then what are our milestones for that, and then targeting all the other changes that we brought up, and then looking at the utilization and redefining utilization.
I want to get back to one more point, because it was never answered. When is the next meeting for the trustees?
The
July.
trustees meet, I can look at the exact date for you.
July what?
Yeah. I'm
I have a point I want to make, because maybe what we should be doing tonight is, because we have.
July
I mean, these-
19 to 20.
Excuse me?
July 19 to 20.
Okay. Got a lot of good stuff here, and we had this independence issue is stay, out, hybrid, which I think is an interesting analysis, that can Patrick put together what we've discussed here? The issue, independence, bring up the facts that we've had, discussion about being independent, discussion about staying with the state bar, and what this hybrid model may or may not be. Also, all the things that we think are really primary, the biggest of which is the outreach, and the fact that we've done a lot of good things, hiring people, we're setting that up. We're moving our offices, so that's, and we're actually doing things, but we don't have the ability to give you any empirical data, whether it's making an effect, because we're just doing it, okay? And it would be great if we had a little bit more time to see how some of these things are ramping out and doing that. And then we come back, this is a terrible thing where I'm going with this.
I know, I hear.
We have another meeting.
I hear
Today, a month early, because we were planning that we were gonna need an extra meeting.
Right, and so, I would like to see if we can get all of this done, and then maybe have a meeting. Today is the 19th, and maybe we meet in June, and meet in, and I don't know what the state bar's calendar was, but maybe you all can take a peek at it, and what's a possible good June weekend.
Well, that's being reviewed.
Yes, sir.
The other thing I'd be very interested in is, what is the largest state that has an independent operation? And how does that, how do they do it? What is the nature of the bar's oversight or relationship, or how do they evaluate the adequacy of that enterprise that they contract with?
I think an important other filter is whether the bar is a mandatory bar, as in California, or a voluntary bar. That's a big dividing line in terms of, there are states where you don't belong to the bar to
Good
practice
point.
law.
That's a
Good
good
point.
point.
Don't we have a lab meeting scheduled for June 9th?
We do know, that's just 3 weeks from now, so.
That's okay.
So-
Is that something, is that a time, is that, I say that's okay.
Do anything else to do?
Look at his face.
You better get a big gift card to Starbucks.
I don't know if I should be sitting next to him, but does that give you, is that adequate, or do we have to shift that
Well,
around?
for what?
Not all the answers.
Fix this problem.
What is life? Can you answer that? That would be great. But, an explanation of the things that we've done that are proactive, that are concrete, hiring, our emphasis, we want to do outreach, especially to young lawyers at the law schools, and
Relocation, clinical review committee.
The
Right.
flyer being put in the new members, maybe.
all those things, okay, and we're making positive steps to, but they take time to take impact, and we don't know what that impact is. And that answers somewhat to what Judge Purcell was saying, and it gives us an opportunity, hopefully they'll understand that we don't know where this is going to be. But we believe that the biggest fault that we've had is not being able to get it out there to the people we really need to get it out to. Then also in that your coming back is giving us a little bit more explanation of being independent, staying with the state bar as is, and answering the SWOT issues, strength, weaknesses, opportunities, and threats under each of those options, including a hybrid one, okay? And maybe we can come back, and if I'm missing anything, please chime in. I'm just trying to regurgitate this when we're spoken at this point. Maybe at our June 9th meeting, we can make a determination and say, okay, from what we ferreted out from now to here, to the 9th, this is what I have for you. And we say to staff, in particular Donna, and to you, Richard, is this something that you feel that they'll really take seriously, that has some significance, that they'll look at it? And you know, we might even say, gosh, you need to give us a little bit more time, but look what we're doing. I don't know. Yes.
And this is maybe for Donna, is the call of the question, do you or do you not, do you recommend, as the Oversight Committee, do you or do you not recommend to spin off? Is it that narrow of a call of a question for the board meeting?
That's why I wanted to know what management's thinking.
Yeah, no, that's a big part of that's a focal point of the question. Yeah, right, so what Patrick had read from Appendix I, that was sort of the lead-in is a regulatory bar appropriately skilled and the appropriate host to provide this service. The input of the committee on that question is a very important factor for the board's determination of the response.
But so all of what, if a whole bunch of information was presented about what's been done, what's going to be done and all that, that may not necessarily answer the call of the question.
Right.
Okay,
Yeah.
so
Good
they
point.
want an answer to the call of the question, is what I'm
I
hearing.
think we have to come to a conclusion, to make a recommendation to them for their September
Yes.
meeting.
So one of the things I'm hearing is this: do we feel that the LAP, it's the duty of the state bar to have an LAP as we have it today?
Regulate it or manage it, I mean, isn't it the statutory construction protection?
Right, but notwithstanding that, what's our gut on it, okay? And is that what?
Yes, and so then I would ask Donna, because I think we know from this, so if the recommendation were, and I think Kelly's word distraction really caught me, because of all of the, we'll call them quote, distractions, in that all the things that you're rolling out to do, right?
Right.
If the answer was, no, not this year, is that an answer that answers the call of the question, or is it a I want it forever answer? I mean, I'm trying to get the, as a lawyer, I'm trying to get the call of the question, I mean, my legal background, right?
Yeah.
That's helpful.
Yeah, right, it'd be helpful. So do we, the answer might be, might it not, task force, I mean, I'm just invited member, but that, no, not this year. But that doesn't mean that what you learn from whatever you get, but at least it's an answer.
Right.
I don't know, or yes this year, and then you've got your answer.
Well, I think the biggest thing for us is either, in answer to your question, Judge Michelle, is that does LAP belong in with the state bar? That's a big, huge question.
Right.
And, you know, I believe it should, okay, but I'm just one person. I don't know, so I'm just gonna, let's answer that question, go around the table. I mean, yes or no, going around the table, just a gut roll. Andy?
I don't know.
Okay.
Not enough information.
Yes, I think it should be.
Phil?
Just
a guttural.
The bar has taken it upon itself to say that as a protection of the public, they should look at mental health illnesses and substance abuse and adequately address it as a public safety issue. So I believe it's part of the bar, and it's the bar's responsibility to do it. It should stay in the bar.
Justin?
At this time, we haven't been able to implement our strategic plan, and so I would recommend that we not move it until we're able to implement that.
Okay. Got to speak up because we're on camera.
You know, I think that LAP needs to be housed where it can do the most impact. I don't think it's realistic to make a call on that in 3 months. I think it's too big of a question. So if I had to take a position now, I would say that it should stay within the confines of the state bar, because the infrastructure is here. We're not, you wouldn't have to set up a new nonprofit. It's just an unknown venture, and there's always a fear of the unknown. So that's my gut on it.
Rob?
Yeah, I agree that it should stay here for now. I think another potential question is, should we initiate an RFI or an RFA, or should we begin a meaningful evaluation of, well, what if in a year we wanted to go outside? Are we obliged to maybe begin that process? Because if in a year or 18 months or 2 years we decide, then it's not going to be flick a switch.
Well, it can't be flick a switch because there'd be statutory change that's needed.
Right.
So,
Years.
so if we were to make a decision in a year, then there would be statutory change needed the following year, and so it's absolute, and MOUs negotiated and all that. So
Right.
it's certainly not a switch flipping.
Okay.
Does, Patrick, the task force, like the ABA, do they have recommendations this? And can you, I don't know if the discussion about task forces on our agenda in the time, but maybe future. What are other task forces doing, and what are we missing by California not having that?
Well, it's sort of it's a big question, but these task forces are being conceptualized and formed as a way to bring together different stakeholders within a specific state, really sort of mirroring what was done on the national level. So you would be bringing together under the same tent, the lawyer assistance program, perhaps malpractice carriers in the state of California, law schools in the state of California, et cetera, legal employers in the state of California, et cetera, bringing all of the relevant stakeholders together to work towards affecting systemic change around substance use and mental health, behavioral health. So I think, quite frankly, I think California is missing out by not yet, being in the at least exploratory stage. So that does seem to be a growing trend within. So,
I believe we should do it, but that's just my opinion. And maybe that's a recommendation this oversight committee is going to make to the trustees, to say that we really want to have a ABA-like task force on this issue and bring all the stakeholders together. And in part, that's why we're asking for time on some of the stuff. Because
the purpose, the sort of essence of these task forces really is the recognition that behavioral health, so substance use and mental health problems in the legal profession, it's too big a problem for one entity like a lawyer assistance program to solve. And because the problems themselves are systemic in nature, you need systemic responses, you need institutional responses. And so that's the idea of bringing all of these different stakeholders, right? Because if you don't have law schools on board, or you don't have law firms on board, or you don't have malpractice carriers on board, these are all integral parts of the puzzle. And so, it's really moving towards a broader effort to really help lawyers and to reduce the level of struggling out there. And lawyer assistance programs are, it goes without saying, an integral part of that, really a pivotal piece.
So maybe that's part of it.
So maybe you might want to make the recommendation, or we may want to make a recommendation, that we believe at the present time it should remain within the bar, but that we are asking that a task force, an ABA-like task force, be formed to further help us move forward.
The only amendment I would make there is that stay in the bar, that the current program improve, continue to implement a series of.
Yeah, that we will continue implementing.
Be focused on.
Does that, this is directed really to Richard and Donna, what we just characterized as our thoughts right here, is that on point?
Yes.
Would that be an answer that would not?
It is responsive. Whether the board where the board will be on it, I don't know, but I think it's certainly responsive to the question of should the bar be the host. The answer is for now, yes, and we want to sort of gain additional statistics, and we want to add additional partners into this conversation. And so it's a responsive answer. If
is the board going to want to wait another, year to make the actual decision? I simply don't know the answer to that. There are certainly, a history of decisions that we thought we were gonna make on one day that we pushed forward to another. So it's entirely possible that the board could say that makes sense, or they could say, no, we need to make a decision one way or another right now, as we are doing with all of our other committees and commissions.
So, yes, I'm sorry.
What if we said, and if we had to make a decision today, it would stay?
Yeah.
I mean,
It would
add
stay.
that to our.
But we also recommend that a
Right.
task
No,
force
no,
be formed.
I get it, and that's more than two. Yes, Larry, you trying to say something?
Well, having, I don't have the years on this body that some people here do, but I don't want to cut off our nose to spite our face. And it seems like we're, from historically, right, it seems like now we have kind of the political will to allow us to implement some of the programs we want to do, right, to hire these new positions. And it seems like we're potentially on the verge of breaking the dam, so to speak, and being able to really figure out how effective we can be, how, if we can implement outreach, how much we can do. And so it seems a little bit rash to me to then say, okay, let's leave and do our own thing when we have the opportunity to use the infrastructure that we already have to potentially further our goals and help more people. That would be my reasoning for why, if we
I think that's very well said.
now, that we should stay. That would be my.
You should craft this report with this next report.
Donna, if they say and say, may I ask a
Go.
question? If the recommendation of the task force was, we believe we should stay now, and they say, the board says, okay, well, we're gonna make that decision, so okay, you stay, but is that a forever decision, or can it be reevaluated?
Yeah,
Okay.
it can always be reevaluated. And I think Larry's framing is important, because it's not a question of what does the committee want, because that's what the committee wants, right? It's what is best for the mission of what the program is about. And so I think your framing of it, Larry, was sort of a good way to sort of talk about why the committee believes staying as part of the bar is the right answer.
So,
Justin? No, go ahead.
You're right, sir.
Is the inevitable end, Patrick, when putting aside the hybrids, if you talk about housing it outside of the bar, is it end up being privatization?
I think on some level, it would be. That would never be, if it was purely privatization, and that meant severing access to funding coming from the state bar, I would never personally recommend that. I couldn't recommend that.
Because I found that's ineffective. I was just curious.
okay. Justin?
Okay, so Judge Purcell asked about what the call to the question was, and Donna brought it up. And there were three reasons that I could find why the Appendix I review wants us to answer the question of why we should stay or whether we should stay or not. One is that the state bar lacks expertise in substance use disorder and/or mental health issues. The second was the lack of utilization, which is something we've talked about a lot. And then the third was that other states are independent and seem to have better utilization. So definitely our comments or our statements should be geared towards that, not only saying what we believe would be best for the committee, implementing a strategic plan, doing more communication, doing more outreach, but we should directly answer these concerns, lack of expertise. I mean, we talked about having all our staff on LEP be clinicians, or at least have the person making decisions be a clinician. Lack of utilization is something we're looking to answer, but we can't right now because we haven't been able to go out and do the outreach that we've wanted to do. And then, Patrick kind of mentioned, the other people do it, and they're independent, but they're not all, they're kind of looking to us. So I think our answer in, whether we say yes or no, or in addition to what we said today, should answer these three concerns, which I don't really think any of us have that concern that we lack expertise, that the LAP staff is not, lacks the expertise to perform And the lack of utilization, like I said again, is something we're looking into. So maybe if we, and I would invite other people to look at the Appendix I review, call the question, and see if I'm actually saying what it actually says. So, because I would rather have us be able to say that too, in addition to we want to do all the things that we plan to do.
Any other comments?
I have a question. I guess I might have misunderstood you, Justin, or misunderstood you, Patrick, but I wasn't clear that there was a sort of established pattern of freestanding service providers, in fact, having greater utilization.
No, I can't say that that's a prevailing trend. No, some do, but others don't.
And some are embedded models obviously have more utilization than we do.
And some have less.
And I think it's the definition of what is utilization, because everyone's,
Right.
that's a huge
Is it a
thing.
referral onto the phone?
And I think, by the way, the referral on the phone should be utilization, because that's
outreach.
That's outreach.
First touch.
Right, it's first touch, right. And I agree with that.
In the intervening time, part of my job was also to get the facts straight from Michelle and the other staff as to, because what I'm finding with these other sub-entities is there's an impression, a folkloric notion about this group. And it may derive from an event or personalities that used to be involved or whatever. So for example, in this group, there were concerns about the evaluation committee, which you have addressed, but it could be that the oversight committee is being painted with this broader brush about, yeah, the evaluation committee wasn't doing its job professionally, therefore no one knows what they're doing. I mean, I'm just saying it goes to your best interest, I think, to be concrete about, you know, here's what we're doing here are the qualifications, and here's what we're doing to strengthen them. So my job partly is to make sure I have the accurate information about what those facts are so that people can actually read what's going on and not see any of these issues, whether it's this one or accreditation or any of the others, as either kind of, you're either a true believer in the cause of this sub-entity or you're not. Because that's not helpful. I don't think anyone wants to say, oh, I don't care about access to justice. I mean, it's really, what does that mean and how do you concretize it? And there's real issues in trying to come to terms with this in the terminology and the comparability. And again, I'm trying to get enough of that together to be helpful, but not suggest that the answer lies in knowing in detail what Pennsylvania or Ohio are doing, because it doesn't. And their definition of utilization, just like in the drug court rule, what's graduation? Well, it depends. Depends on the program design. Depends. You know, you can't say that you can just take these two percentages and compare them. Well, with this one, if you test 30, you're out. This one, it's a disease. We look at it that way, and you can test 39 times, and you're still in. This one's 12 months. This one's 36. I mean, comparability is tricky and can be really misleading and very political when you just choose to cherry pick things that make your point, right? So I'm trying to avoid any of those problems with this, and well, it's somewhat helpful to be sensitized to what other states do. I'm not sure, you know, again, everyone wants certainty or a source of authority that's going to make, these are hard decisions, and in fairness, this is one of the harder ones because there are some of these sub-entities that clearly fall on the regulatory side, and they're like client security. Then it's a question of just fine tuning, really. What's the process? Can we make it go faster? Can we streamline it? As someone pointed out yesterday, and we briefed the programs committee of the board and the regulation and discipline committee of the board on this appendix I review, someone said, look, you know, part of what we're dealing with also sometimes the workflow within these sub-entities, the ones that are actually doing work, like mandatory fee arbitration or client security, it's a workflow that's designed around having a volunteer entity involved. So if you were really designing what's the best way to get this person their money or to make a decision about whether they should get their money, the path would be a lot straighter. So they have a different set of issues and they're easier. Some of these have aspects of both. You could argue that some would say, well, only the regulatory part of substance abuse is a public protection function. Other people say, no, it's all public protection because at the end of the day, there's people practicing law that have problems that are impairing their ability to do that well. So, and that's really
it's not obvious which way to go there, and this is one of the non-obvious ones. So this has been, at least for me, a real education to hear the perspectives of all of you. And at the end of the day, it's also, I think the overarching question for the board is, there's no question that capturing the expertise of subject matter experts and practitioners like yourselves is highly valuable. That's why there are so many entities like this in state government all over the country. The question is, what's the best way to use your expertise and separate and have that inform the work of staff and the programmatic stuff in the best way for the people we're trying to serve, which is the public and the people who need our help, or the people coming to claim money or get mental health counseling, whatever. So, yeah, the reason why this is hard is because it's hard.
Well, these issues are subjective in many instances rather than objective.
I'm trying to at least get the right set of facts together. So then reasonable people could have different opinions where they should be based. And it seems harder to say this these days, but facts matter. There are facts.
Yeah. So what I'm hearing you say, because the word concrete kind of hit me, and I between the call of the question, the three questions here, and you're saying what concrete facts would frankly, be impressive to the board, would give them a sense of confidence. So, for example, is this what maybe we're talking about? Instead of saying the task force plans to do outreach for law schools, it would be more like the task force will undertake a new methodology that's law school outreach, which would intend to include a visit at every orientation for all 56 schools within a certain period of time. I mean, are those the kind of concrete things you're saying, rather than, from what I've heard you saying, that maybe just this notion that things are discussed and maybe not come to concreteness, that if they're there, even if they're just planned, or other concrete things like the offices have been moved to protect confidentiality, program manager has been hired, is a clinician. All of these concrete things, either past, present, or future, matter, and they have to be followed through, but they matter in concrete facts. Is that what you're saying?
Yeah, in other words, what I'm trying to suggest is saying, we're looking into it, trust us, it's complicated.
Yes.
That's not going to get much traction.
Right.
So to the degree that not over-promising or just blowing up things to make them sound more figured out than they are, just I think it would demonstrate a grasp of what the challenges are and how you're addressing them to the extent that you have been able to so far. And
Not future, you're saying not?
oh no, including future,
including
because
future.
Everybody's looking ahead
So
here. So
we just have to then, what you're saying, Richard, is when we say we're doing outreach, we're going to do greater outreach with law schools. You want, Judge Purcell was saying, we're going to make visitations, we're going to work with the deans of the law school, we're going to make a presentation with the deans on the 21st, and we're going to continue that. Repetition is important, and any sales 5 times.
Maybe letters have already been written. We
Right.
write a letter to every dean by that time.
That's right. We will also have, we're inserting, right? We will specifically, so you want everything that we're doing today, we need to document and say that we're doing it.
well, and tie it to whatever the
Right.
management challenge. And for some committees, I don't know about this one because I'm not that familiar with the composition in terms of people's backgrounds. But for some, it's a reasonable question to say, well, are you really recruiting the right people to be on your committee to do all the things your committee's supposed to do? If it's just kind of a whoever wants to raise your hand, that doesn't.
Well, and that's just for your edification. This really was never that. This is really an odd committee.
But qualified.
Right.
I
I'm the oddball. But when we have certain requirements for this committee. Some people have to be in recovery. Some people have to be experts in the area of recovery, mental health, alcohol, drug addiction clinicians. That's why we have physicians, we have PhDs on here. We've always looked at people involved, in psychiatry is an area, and we have people here that are in recovery, and from Andy, Justin, and Justin is one of our superstars. He went through the program, and so I'm not speaking out of school, but he's told me several times. It's really saved his career, you know.
I have a career.
Yeah.
That's why I'm here.
That's right.
And you are the foremost leading expert on the in Patrick.
That's right.
In the country.
And we, you know, generally, you roll off these committees. You can't stay here forever, you know. We've had exemptions always to stay on because of our qualifications.
Right.
And so this is, when we say this is a uniquely qualified committee, it's very much so, because these are people who have an interest, know about the subject matter. And I will tell you, in deference to a lot of people, that there's still this prejudice, taint, that drug and alcohol addiction is not a disease out in the community, and just in general public. And there is this taint that, you know, I've talked to a number of bar associations where they just say, well, they have the drug problem, they have the mental illness, I have to pay for it, forget it. You know, and not realizing this impacts us all at one time or another in our lives, in our personal lives. I mean, this is the wrong group to say that, but in the general public, I'm sure there's a large percentage of people just walking down the street that drugs, alcohol, and mental illness has affected their family directly in a terrible way. And so,
1 in 4, I think.
pardon?
What is it, 1 in 4?
I was going to say that.
Well, it's
but I
about
wasn't
12%, in
sure.
any population, it's about 12 to 14%.
And it's a huge number, and to think that lawyers are above this,
It's higher among professionals.
right, it's actually higher. And so, this is a uniquely qualified group of people that are looking to try to come up with a program that works, and I think it's a very well said what Larry said. We're in a new horizon, we're here, let's move forward, we're making progress, let's move forward with what we've got, and let's go, we're running with it. And we're making all these changes, and we'll itemize them out. And we have some ideas where we haven't hired a communications as a person, or that.
Analyst, yeah.
Analyst. And, but it's out there. And we've got our move, I don't know, when are we moving?
We moved in April, and
Early April.
Yeah.
yes, and we haven't publicized it very much yet, because at the beginning we didn't know if we were actually going to be able to receive mail at that address, so we didn't want people to start sending. But we have that worked out now. Now we can receive mail there too, so that's something that we are going to publicize more going forward.
So they'll change the address on the website, change for LAP, change the address on their business cards, et
And
cetera.
by the way, after this meeting, I'll be going back over there if anyone would like to come
Across the
with me.
street, right?
Yeah, just directly across 8th Place, so if anyone wants to walk over and see the new office, you're welcome to come over.
So, all these things are very, you know, and we'll obviously have to have this in our report that you present. But that's for your little bit of the background on this group.
Yeah, and I could say, as a person coming in trying to learn about these 12 things, not only how they're done here, but in all of the other states and other regulatory, it's a lot. So the board members are kind of in the same position. They have obviously more background in pieces of it, but you know, each of them probably knows more about a couple of these than the others. So again, trying to get with the staff and the committee and get clear, concise descriptions, not every nuance and detail, but the basic things of, for example, in mandatory fee arb, there seemed to be some that thought the committee did arbitration. Well, they don't have anything to do with arbitration. They have to do with educating and training arbitrators. The staff do all the work of assigning the arbitrations out to a volunteer arbitrator. So there was just a misunderstanding of what the function by some people, not by all, you know, as to what they do. So just making sure everybody's on the same page and has the same basic view of what the work is and how it's getting done, and so that the question of what's the best way to do it, you know, as Larry was saying, you know, if you were going to do this the best way, what would that look like? That's what they're trying to get to.
So are we still, we're having a meeting June 9th.
LA or San
Well,
Francisco?
we had, last time we met, we had decided to cancel the June
Yeah.
9th meeting in favor of making this meeting today, and then another one maybe in mid-July, and then going back to the regular schedule in
Right.
September.
But due to the fact that we need to
Yeah.
answer before,
Right.
the meeting is July, you said? 21st.
1920,
sorry.
19, so we really should do this maybe in June, right?
You want to go back to June 9th? So that means we would need to have the agenda posted in about a week and a half. So.
And I think the agenda item really should be all about just this one subject matter. Can we
Patrick
do
is
that?
looking very confused, so.
Where I just, it seemed to me that you sort of took a poll.
Yeah,
Sort of-
yeah, that was kind of how I felt too. It seemed like you answered the question.
Yeah, I thought that for now the question was answered. Now, I'm going to continue and I'll need to work
Okay,
closely
your
with the
point
state
taken.
bar staff to, you know, to really develop that concrete list of all the things that have been undertaken.
Of course.
Good.
And so that'll all be going into my report, but I don't anticipate anything in that affecting the vote or, you know, informal vote that was just sort of taken as to where people stand.
Okay, so then,
So do you
moving-
prefer a July meeting to talk about what's going to
Go
get
into
sent
the
to the
report.
committee, or after to talk about what happened at that board meeting?
I think we should
After.
have it before the meeting so we make sure what we want in the report is in the report. Right?
Well, so, right, what Richard, I think, said was for July, he's gonna present an oral report with oral sort of recommendations that we formulated to date. And then based on the input that he gets at the July meeting, he will finalize the written part of the report. And so I think Ms. Shell's question is sort of a good one. Do you want to react to what the board says in response to Richard's presentation? And therefore help him sort of finalize your reaction in his report.
Can that be done electronically? Could you filter that out to all of us on the Oversight Committee to see what you're going to say?
Now I have to say what Patrick had. It's, well, yeah.
Would that be a serial meeting?
If, I mean, we could put, we certainly couldn't communicate with one another to get feedback sort of as a group over email.
What about a two-person subcommittee?
Okay, can we do, that's all right? Or was it
What date in July are you gonna be making this presentation?
21st, 19th and 20th or something like that?
Of July?
Yeah.
So what if we had a meeting right after that, and then we could finalize the report for September?
What'd you say?
What if we just bumped our September meeting up to like August, early August after
Yeah,
the,
after the July meeting.
yeah, after the July meeting, then we have an opportunity to hear what they had to say, and then we have an opportunity to discuss it as a group.
That's fine, I was trying to figure out whether we'll exclude somebody to see what Richard was gonna say before the July meeting.
Okay.
And that,
Yeah,
we
I mean,
can't have a meeting.
Yeah, and I'm trying to, so part of what I'm trying to do is take Patrick's reports, take the sense of this group, take the direction I'm getting from the Board of Trustee liaisons to this group and the Programs Committee and the RAD Committee, and synthesize all those and at least let everybody know what everybody's thinking is so they can make the best recommendations.
When do
So-
you think you could have that? You will have that done?
Yes, so it's not clear that there's gonna be a document. I mean, I think what I heard Richard say, and I've heard him say in other contexts, is he's sort of reporting back to the
So like an oral
board,
report.
everything that he is, all the input that he has gotten. The inputs including Patrick's report, the inputs including everything you've said, the inputs including the board liaisons who are assigned to this issue, who, the names escape me right now.
So what I will have in July is, or else I won't know what I'm saying when I stand up, is some notes, some outline that will obviously have some content in it. So yeah, I will I will
You gotta have a
endeavor
document.
to do that so that that could be considered. Because, again, I think this is one of the more complicated ones in the big portfolio of stuff. I mean, I'm just trying to manage the workload. And I originally had thought, oh, I'll have the whole report drafted up for the July meeting. Like, nah, that's really not gonna happen.
Okay, I got it.
So yes, there will be an artifact of some sort that will try to capture not everything, but at least the issues and the sense of the committee. And I think that the committee's job is to say, yes, you reflected our perspective accurately.
Right.
And then we'll go from there.
Okay,
Yes,
so
yeah.
I just have one final question for Patrick.
Is that-
Is your report going to, is Patrick's report going to be, reflect the task committee, and, but does it also come with a recommendation from Patrick? Is that, I was just curious what your report
Real good point.
is. Does it ultimately have a recommendation from you, or does it, which is influenced by the task force, or is that a separate thing and then a recommendation from you, or none? I'm just curious what it, call the question again.
I mean, going into today's discussion, that was a little unclear to me as to whether, and I think now it will. I mean, I have a better sense. I think today's discussion really has, crystallized some things for me that I ultimately will have an analysis and a conclusion. If you want to characterize that as,
Yes.
as a recommendation, then yes.
Okay, great.
You know,
So with that understanding, maybe we don't have to have an extra meeting, is what we're talking about, correct?
Well, our next regularly scheduled will be in September. You want to meet before September, right?
Right.
So maybe like August 4th, you'd be able to say, this is what I talked about at the board meeting, and this is the feedback they gave me before we prepare the final report.
Sure.
So August 4th is the first Saturday in August, so it'll be about almost 2 weeks after that board meeting. The Saturday before that is July 28th.
And I'm sorry, Patrick, what? Oh.
August 4th works. How about everybody else? Okay, so we'll shoot for August 4th.
And get rid of the September 15th, or?
Well, let's keep the September 15th there, just
in case.
Just in
Okay.
case. but-
COLAP is September
Cancel June
25th to
9th.
27th.
Say- Excuse me?
COLAP is also September 25th to the 27th.
Right.
Okay, and we'll take June 9th off of the public.
Right.
The,
I think it's already removed.
it's on the internal calendar, so we just need to take that off.
Okay.
Because I think once the communications person's on board, we really do need to do a strategy session of communication. I mean,
But
that-
I do want to caution, sort of communicate, sort of broad communication strategy, broad sort of website, web page design is done through our communications office. So we're really looking at this more of an outreach person. They're not going to be issuing press releases or doing a separate website that has a different look and feel than the rest of the State Bar's website. So I want to make sure that you don't have a misimpression about how much flexibility this person will have to sort of design a communication strategy. We're really looking at it as an outreach strategy.
But we'll be able to work together with the communication.
Yes, because one of the things we have talked about is, maybe we get a contract of a person who hosts a website that's extra, so it doesn't have the State Bar on it, that is separate, and then, you need the people who are updating the content.
We have earmarked funds that we asked for in the budget, which is probably why we're a little over this year, to specifically do that.
So my concern is we don't have a strategic document that's outlining our overall communications, whatever, and I think we all need to be invested, in which the task force would be awesome, because that would give other input into that. So, good point, and only sharing just because I don't know if you that hard.
I just want to make sure we've got sort of realistic expectations about sort of communications and communication strategy and design of, our person's going to send out X number of tweets a week. All of that gets coordinated through State Bar Communications.
Stuart,
Yes.
regarding the August 4th meeting, are we picking a location or do?
Well, that was my next question is it going to be here or in San Francisco, or is it going to be in our new office?
We can't do it at the new office because of the other support we need for catering. and for-
Okay, that answers that question. So LA or San Francisco, does it make a difference?
Shall we vote?
I think I'm the only person from Northern California.
Oh.
So, I'm a lot, no, but I wouldn't mind coming back.
So there is, I'm in July.
Availability and access are also issues.
So I'm not sure what this means, but it looks like in San Francisco on August 4th, there is unless there's some committee called building construction, there is some construction going on on the conference room floors in San
Okay, well, let's
Francisco
just-
on that day.
So let's just have it right here in
Right here
LA.
then. Justin gets another plane ride.
Okay. And secondly, the agenda item is going to be everything that we've been discussing in this item.
Building committee.
Yeah, the appendix I.
August 4th.
Every other committee reports up through me, and I'm not familiar with them. so-
You don't know that
So
one.
circling back to Patrick, do you have a date certain for your report in June?
Not a precise date, no, just hit it in anticipation.
Did you say first half? I'm just trying to plan out my own.
Middle of the month, I would say. Yeah.
So straddling the first half and the second half.
Okay.
Oh, one more question. Is the next meeting going to be teleconference or webcast or?
I have no problem with it being,
So the BAR's policy is for all in-person meetings, they are webcast.
okay.
If they are video conference meetings, they're not webcast, because we'd be webcasting a TV, like screen, so that seems odd. But for all in-person meetings of all of our committees and commissions, including the board, those are all webcast.
That's fine, webcast, fine.
Okay, thank you.
We'll get to see Joe again.
So technically, we could actually watch the board
Yeah,
discuss this
Yes.
question.
yes, absolutely. You could watch it live, and you could watch it for weeks and months, and I don't know how many years later.
That's a good point. That's a good idea.
Yes, so if you go to the State Bar website, and you look up, so let's see, there are many ways to find it, but if you look up, if you're on you go to About Us and you look under State Bar Board of Trustees, you can actually click straight on meeting webcasts, and it takes you to the list. Right now, on top of the list of meeting webcasts is LAP Oversight Committee in progress. And so we can click on that and have this weird dual thing going on. And then right underneath that are all the
How do I
archives.
look? Okay.
And it takes a few days for the webcast to be uploaded to the archive, because they add the closed captioning that's being done in Colorado right now, and so it takes a few days to edit all of that together. But so soon enough, yesterday's board meeting, the presentations that Richard and I made to the board meeting will all be available there.
Great.
Are there public members allowed in the board meetings?
Yes, they are open meetings. They have sessions that are closed, but the chair of the board actually goes to fairly great lengths to announce to the public, okay, when we start, tomorrow, we're going to start in closed session. We will return to open session at 10:30. And they return at 10:30, and if they hadn't finished the closed session, it's on them, and they go back and they do that later, because he wants the public to not be waiting around and to actually have some certainty, this is when the public session is going to happen, this is when I might be able to give public comment. So yes, they're fully open to the public.
There's something I want to tell the whole committee. I was telling one person today, excuse me, there's a new way that you're getting the agenda and materials. It's being sent through Lyris listserv. I was originally signed up to send it to the whole board, but we have our LAP group now. The Lyris message, when you open it, it will have the agenda, and then when you look at the agenda, each attachment item is highlighted. So when you click on each agenda item that has an attachment, that will come up on your computer. They used to be emailed to you, but I think the BAR's policy now is to do it in this way, that every department is doing it that way. So if you have any questions about that, or if you don't get the materials, let me know, but they will be sent to you via email through a Lyris message that's, I think, coming from me or the LAP.
Right.
So we're about to run out of film and camera. We're gonna do this in 3 minutes? I can do this.
All right,
We've
so
got one more
This
agenda
last
item.
one in
We have,
3
I
minutes.
know that. Okay, great. So, we're moving along. Go ahead.
Film in the camera.
So this
The
last,
state-
last item, State Bar legislative priorities, is informational, so there's nothing you need to vote on. This fee bill, the annual State Bar licensing fee bill that's coming up is AB 3249, and there are 2 provisions in it that relate to the LAP. one would authorize LAP funds to be used for treatment services, which is something we've talked about for a long time. So that's interesting to know. And the second would require $1 of the $10 paid by each active member from their licensing fees to go to a statewide nonprofit corporation established by attorneys that has, for the last 25 years or more, provided peer support to attorneys recovering from alcohol and substance abuse in a confidential and anonymous manner. So that is a very lengthy description. I think there is only one organization of the type in California that would get transferred this $1.
Okay.
So, I know everyone's anxious to leave. As a non-attorney, I don't know how that got put together and got put there. What were the pre-discussions? So, I guess my concern is that someone's group, whatever, went and did that, and they know of us, and no one came and talked with us, and we didn't have a discussion. And so I think there's the issue of that in general and what that would do to our budget, and what does that do for communications, and there's some assumptions made in there, so this is going to people who we were just talking about may not be educated, and what are the assumptions and what is the best way, and that's being done independently. So if we step back from the money part and we just talk about that we're a community, can we reach out, since they didn't reach out to us, maybe we need to reach out to them and sit down and have a discussion about, what is it you're trying to do here? What maybe would be the best way? And, we really do need to collaborate and have open discussions so we're not hit blindsided, and maybe you feel like you've been blindsided by us in some ways. So, somehow we're missing something.
Yeah, so there was a lot of activity going on in the legislature with one organization in particular walking around the legislature talking about the need for additional funding, which they are of course entirely entitled to do. As it had been reported back to the bar, the legislature, there was significant support in the legislature for a proposal to redirect $1 of every $10 of the licensing fee. There had been some significant lobbying going on and really developed quite a lot of support for that approach. The discussion was then presented to the bar that the legislature would like to put that provision in the state bar's annual fee bill. So being aware of the political realities of what's going on and the significant support of the legislature, that item was presented to the Board of Trustees at their April 16th meeting. And the recommendation from staff was that, although there's sort of an inconsistency if you read the agenda item that was attached to Michelle's agenda item, the recommendation from staff was that the board be neutral on that provision, but that the provision would end up in the annual licensing bill. The board actually took a support position on that provision and inclusion of that provision in the licensing fee bill.
Which entity promoted this? What's the genesis of it?
So I believe it came from the other bar, and they were doing what you do to make sure that you've got sufficient funds to operate your organization.
So my concern is that, one, if the Board of Trustees, which we're talking about a report to the Board of Trustees, made a a promotion without input from their trusted lower advisory board, I have concerns about that.
They didn't promote it, they agreed
They endorsed
to
it.
support it, yes.
So again, to me, that's promotion. You didn't take a neutral stance, you endorsed it, you promoted it, with absolutely no input from the professionals that we just determined that are on here. That one, what is the impact of this program? There was no report on that, no assessment. Two, what then is the evaluation of the peer? So I support peer, I see a value, so this isn't about peer or not. This is about coordination, programs, things of that nature. So with no input, we're going to take a funding stream, and then what is the oversight and coordination and everything with that? I think in light of everything, we just spent a huge chunk of time, and there's this other political thing going on that it just concerns me.
Mm-hmm.
And I think that there's some relationship building that we need to do, or there's miscommunication, or there's something, because that's not good.
Which nonprofit corporation or entity are they proposing that the money be transferred to?
So I believe, I don't.
I thought it was the other
I
bar.
think the other bar is
The other bar.
it would clearly qualify under the terms of that
So,
definition. I don't know if there are other entities as well.
There isn't. There is-
Judge
there
is
isn't.
the other part. So Judge
Terry.
Terry, who just resigned, was the he held the seat for the other bar, correct?
Right?
Yeah.
And so he was the representative.
Mhm.
I believe in our minutes, we've had so-and-so appointed in his position, right? Wasn't
Well,
there?
no,
There's
we
a
always
whole
had
lot
a
of
member of the other bar
Right.
appointed to this committee.
It was supposed to be Jim Heide, but.
Right.
But it's
That-
closed.
We haven't had it, we were lacking getting appointments, and I don't know what the reason is. I do know there have been people who have applied, and what is the status?
Yeah, so the board has been holding off on making interim appointments to any of the committees and commissions pending the outcome of the Appendix I review, because part of the analysis on many of the committees and commissions is about the size and the composition of the committee members. And so we have not been doing any interim appointments.
So the other bar knows us. They know many people on this committee. They know this is an open meeting. They have a position that is their position. So, it would have been nice if they had come and said, hey, this is what we'd like to do. Let's work collaboratively, or, we have these concerns. What do you think is the best thing? And it would have been nice if the Board of Trustees had asked for our input, at the very least for us to say, hey, we'd like an opportunity to sit down and discuss a good plan overall. So, in the political world, they did an end run around, and then now you have to go back and you have hurt feelings, you have whatever is going on, resentments, and I'm not saying I have that, I'm just saying this is what happens.
I do.
Yeah, I do too.
And, then it makes a much more difficult working relationship. And back to Larry's point, what have we done for the people we're trying to help? Because now we're going to have mixed messages, we're not working together, and we have, because of our stuff, we have subverted the intent and overall goal, and not, and they're great because they also deal with, family members, which is important, because that's a huge thing. So I don't know what we can do at this point to rectify. And so I don't want to just complain, I think that's set the stage, but what can we do to regroup?
Does this
Well,
also beg the question as to how or which services that the other bar would offer?
Well,
that
and I should
differ
like to
from
know
us?
the nature of the oversight of these monies, these
So,
funds.
yeah, so there's no language that would direct any oversight. The money would be redirected, the $1, so it's about $190,000 would be redirected to an entity that meets the definition in that statute, and it would be used and overseen in the way any of the funds of that entity are used and overseen.
Right.
What would be the difference in the services they would provide?
So, as I understand it, they provide peer counseling services, but not, they don't use.
Support, not counseling, peer support.
Peer support,
Yeah,
sorry.
it's peer
I
support.
think they're less expansive than what we,
And it's substance use, substance abuse.
It's what?
It's substance abuse, not mental health.
Yeah, there's no mental health component here.
No, only services.
Right.
And there's no monitoring involved, as far as I
And he
know.
says it's
That's
like
my
an AA
understanding,
meeting
yeah.
for lawyers.
Yeah,
That's
and there-
probably-
right,
That's
it's a
description.
system of that, and there's no monitoring or anything involved with this.
To piggyback on what Kelly just talked about, this is the second year in a row that something's been slipped into the fee bill without, that affects our budget in a significant manner without our knowledge. To what extent does the state bar inform the board of trustees or whoever is in charge of the legislative agenda for the state bar, do they make an effort to notify the subcommittees about what they're doing? Because, like Kelly said, it would be nice for us to have a say on, whether or not the state bar can transfer reserve funds, or whether or not the state bar can, transfer $1 out of our $10 fee to another entity.
Yeah, and so the board certainly makes every effort to do that.
What efforts were made?
But sometimes the legislative process moves very quickly.
I understand.
And I think on this one, the support that we heard that was being developed, that sort of came about in the legislature, the support for this provision, it became obvious that the support was there for this provision, and the board made a decision, a political decision, on what the appropriate response was, what they thought the appropriate response was.
Without input from us.
Right, that is correct. They did not reach out to.
I believe under these circumstances that our committee should ask that a member from the other bar be appointed to our committee, since we have no member at this time. I understand that they've frozen, but under the circumstances that we would have had information about it if Judge Terry had still been on our committee. So I don't think it's right that we have no representative from the other bar on our oversight committee.
But I think it gets to the larger question that Justin, I think there's two questions. Is one, what Justin said, because it still is not answered, is twice this has happened, that it's a lack of respect of this board. I mean, that's really what it is. I don't care about the legislation process. If it, even if you're going to blow off what we say, you still come and ask someone to say, you sit there and you respectfully listen to them for 15 minutes while you're thinking about your dinner tonight, and then you blow them off. But we didn't have even the opportunity to do that. I mean, we had nothing. And so, and if, does it go to the point that, the other bar is out there obviously advocating for themselves because they want to get paid, because they basically want to be paid a full-time job to do supportive counseling, or to subsidize their AA meetings and such. So they have an inherent interest. We're volunteers, we do this, but is it that we need to somehow think about how do we advocate for this board? Because we're not getting the information, and then we're blindsided, and then it impacts the success of the program. I mean, it's like, what should the board do?
So one of the things, the committees and the committees, commissions, sub-entities of the board, the bar as a whole is the one that takes positions on legislation, and so the committees and commissions, can make recommendations to the board on various things, but the bar would be the one that would actually take that position. There is an expectation that the committees and commissions are not going out there on their own and representing, we're here as the LAP Oversight Committee, and this is what we are advocating for. That's antithetical to the notion of this being an entity of the Board of Trustees.
I don't think that's what Kelly's saying. We're not asking for the ability to go advocate for a position on our own aside from the bar. We're simply saying if the bar is going to take a position, that position should be communicated to this committee prior to any action being taken that's especially going to impact the budget of this committee.
Yeah, no, that's
and in addition, if the other bar has a seat at this table, should they be lobbying?
And for that reason, I had a conversation with Jim Heidi about this, and he abstained from the vote about this because he's also a member of the other bar, and he felt he had a conflict of interest because he's expecting to be appointed to our committee. So he abstained in that vote. But I feel very strongly that under the circumstances of what happened, that they should allow us to have a member of the other bar on our committee.
I mean, there are a number of third-party drug alcohol treatment programs that are independent besides the other bar. There's Matrix, there's Smart Recovery, there's all kinds of things out there. Promises Betty Ford has a professionals program. There's all kinds of opportunities if this is what's happening, like for people to pitch.
But they're not receiving a portion of this.
We are providing services to
lawyers. There are plenty of others.
And just because they've been around for 25 years does not necessarily mean they're better than Betty Ford or promises or any of the other words.
As George Orwell said in Animal Farm, all animals are equal, but some animals are more equal than others.
It also, I think, begs the question of whether or not, given the fact the State Bar's mission with regard to protecting the public, Betty Ford, for example, these other entities are not charged with that. This committee, the State Bar, is charged with that mission. And so taking the funding, basically, without at least communicating with folks here would seem to be problematic.
Should have been vetted, and actually, if you go back to the history, this was vetted. 20 years ago, they were getting money. The State Bar decided this was not a good use of the money, it was not regulated, they never knew where the money went. And they decided the money should not be sent to the other bar. They should all go through the LAP. So I still think that's what should happen. I was just totally taken aback by it, that this was that came about. Because that was totally vetted 20 years ago.
Well, what interface do we have with the board of
None.
trustees?
Other than, we've always provided a seat for them with the LAP.
And I'm your direct contact.
Okay.
Yeah.
I mean,
That's
look, right, I mean, this might be a bit of a crass solution, but I'm a member of the public too. Why, I don't see why we can't just talk to them at one of their meetings and air these grievances. I mean, I understand you're kind of an intermediary here, but it's also not fair to beat up on you, you know, kind of kill the messenger, right? I mean, the message is clearly not getting communicated, or they don't
We're not
care.
beating up on her. Yeah.
Well, no, I'm not saying we are. I'm saying that, you know,
I think
if
I've
it
been
gets there.
respectful.
No, that's why I asked if public could attend these meetings, because I'm thinking maybe we should be going to.
Right,
these
so
meetings.
that's what I'm saying, to your point, that this has happened 2 years in a row now. I wasn't here last year, but, you know, I don't know what happened after the first one. If I were on the board of trustees and the LAP members showed up and, you know, gave me a piece of their mind, it might make me think twice next time. And if we didn't do that the first time, maybe that's why they were inclined to do it again this
I
time.
mean, by funding the other bar, which is what we're doing,
Right.
the State Bar is saying we're endorsing them over all other entities.
The legislature is saying that by directing it in the
Yeah.
statute.
Yeah, well, I think that's not good.
But because
Yeah.
the State Bar promoted,
Oh, yeah, I was gonna say,
however,
that's
endorsed
good
it,
lobbying. That's
I mean,
politics.
indirectly, and Stuart's correct about the 20 years ago and the history of that. So what, if anything, are we able to do at this point in time? Can we do a letter or something that says, or, I mean, what is it we can do?
Yeah, I mean, I think I think there's nothing that would be likely to affect the outcome at this time. I think if you wanted to, submit a letter to the chair of the board, that would be appropriate. But I don't think there's anything that's gonna affect the outcome.
And that's what happened last year. When we found out last year, it was basically, there was nothing we could do at that point in time. It was like a done deal and
Donna, do you think a letter to the board would affect a possible future situation in the sense of just getting input? Because that's what I'm hearing that the task force wants is an opportunity for input, not a control the decision.
Yeah.
Do you think that would help a letter?
It certainly wouldn't hurt.
Okay.
I think it'd be fair to include in that letter that members are contemplating resigning from this committee based on these kinds of procedural oversights.
Who's gonna offer this letter? I will offer that letter. Stare.
Mr. Chairman.
But I'm gonna ask.
Well, you've got a better letterhead than we do.
There you go.
They already
Higher
did that.
floor.
So
Higher floor.
what's the risk factor? So I'm up for the reappointment, because so you write a letter like this, and then somehow I don't get renewed.
Nobody's, there's a freeze, nobody's being renewed now.
Right, but,
Who's your appointing authority?
I'm sorry, excuse me?
Who's your appointing authority?
I'm in a mental health position, so I'm one of the ones that, I've been here with Stuart a long time, because I keep getting reappointed. And so, I'm a vocal person, but I think I'm respectful and fair. I think I'm a good member. But, you know, when you start doing something like this, then, you know, then you may never see me again.
What if the letter is authored by and signed and supported by the entire committee?
Yeah,
Yeah.
that's what I
Doesn't have to
envision,
be
not an individual.
Okay.
Yeah.
And the letter probably should not only go to the Board of Trustees, but probably also to the Assembly Judiciary Committee, because it appears that they prepared an analysis that addressed this issue.
So that's where I would say that would become an issue where a committee of the board is independently sending something to the legislature. I think that would have a different impact on the board than a letter that says to the board that we're, you know, concerned about these procedural oversights and we think it's appropriate for the board to have sought the input of the LAP Oversight Committee before taking any position on something that would affect sort of the program that we oversee and the funding of that program. I think they're sort of very different impacts of those two letters.
So we just CC the Assembly Judiciary Committee? Is that?
I'm suggesting that I think that is inappropriate.
Thank you very much.
Thank you, Patrick.
Thank you.
Thank you, Patrick.
Thank you.
Okay.
Do you have a suggestion as to how the bar should first, the state bar should first address this issue with this committee?
With
this oversight committee? These types of measures?
So again, it's sort of, part of it becomes a question of timing and you know, if this was something that, you know, there was an opportunity to come to the Oversight Committee first and say, this is on the horizon, give us your input. We give the input to, there's a sort of a group of folks that work with our Chief of Mission Advancement and Accountability that make recommendations to the board on, that help him shape the recommendations to the board for legislation. So if we had the opportunity for it to come to this committee saying, the board is going to be considering this amendment, what do you think? This committee could have made that recommendation through that process, which could have then been included in the agenda item to the Board of Trustees for their April 16th meeting. I think it was sort of timing more than anything. I think it was entirely timing more than anything that prevented that from happening.
Prospectively, though, not retroactively. You're addressing
Right.
this as a retroactive issue.
So on a going forward basis, assuming, I think, and that's sort of a good point, sort of the letter laying out on a going forward basis that that we have an opportunity before the board hears a recommendation about taking a position on legislation, that it be that the committee have an opportunity to weigh in, and if timing doesn't allow for the full committee to meet, that we at least have the opportunity to get the input of, say, the chair of the committee, or you know, if you know, informally we want to say, you know, it's, you know, I'm gonna decide that informally, you know, if something like this comes really quickly, I think we should include Stuart, and I think we should include Larry, and you know, and so that's what we would do, sort of in a quick informal turnaround. We can suggest that kind of process in the letter.
See, because we weren't allowed to hire, we couldn't get our communications person. Because we didn't have a communications person, no one knows the value of what we're trying to do. So then you have people who have self-interest, who go and lobby, make their point, no one has any other information, and then they honor the support.
So I think that's not necessarily true. The legislature is very aware of the lawyer assistance program. What they're also very aware of, taking a look at our budget, is that we are sitting on a projected 154% reserve. And so they look at that, and they have their support for the other bar just as an entity. There's a support in the legislature. They're saying we need a little bit of extra funding. They say the lawyer assistance program has been underspending the revenue that it's been getting. So we move $190,000. That will have the benefit of providing the extra support to the other bar and wouldn't create a financial detriment to the lawyer assistance program. I don't think it's that they didn't know what the lawyer assistance program was. I think they were looking at the budget and the underutilization.
Which we were forced with the underutilization, and there's absolutely no metrics that are being put on them to use that $190,000. So they don't even know what they're buying.
Yes, that is true.
And,
Which I think is probably violates the GAO rules, but I don't know that.
And it's not clear to me that there's really good oversight as to how those monies are gonna be spent.
Yeah,
And
there's,
what other
there's certainly
organization
nothing
is
in the
gonna come forward
statute.
next year and say, we want a dollar?
Right, that
We'll-
is certainly,
we'll
that is certainly a
forward.
question I can't say, well, of course that would never happen.
You know, looking at it prospectively, though, the bill has been, it doesn't sound as though the bill has been approved by the Assembly, which means it hasn't gone to the Senate.
Right.
So there's still an opportunity for change to be made if the State Bar is going to address that.
If the board wanted to change its position from a support position to oppose a position, yes, theoretically, there is time in the legislative process to do that. The bill is sitting in the Assembly Appropriations Committee, I believe, right now. It'll be heard by that committee, heard on the Assembly floor, and then it'll move over to the Senate, and the process starts again. So certainly there is actual time.
So
Do
how do
I
we have a
honestly believe the
meeting then?
board's gonna change its
so how do
position?
we
No.
get more than a letter, but we call someone and we say, hey, Donna and Stuart, let's have a meeting and talk about kind of what went on, and
Here's the 20-year-old vetting that resulted in the contrary decision. And, you know, there is no oversight. So
Can we
we
find that,
should-
Stuart? Because some
we
of us
should
can
reverse
attend.
our recommend.
We can attend that board meeting, and we can bring this up. If it hasn't been, I thought that it had been voted on.
Well, our
It's
intent
been,
to
it's been voted on by the
attend
board,
might
but it's still in the
It hasn't
legislature.
gone, it hasn't gone to the legislature yet.
It hasn't,
It's
it
in
hasn't
the
been
legislature.
approved by the entire legislature yet.
And so if there's still time to change it, you know, a letter is a letter, and a person reads it, but, you know, maybe this is where we need a phone call and a meeting, and we sit down and just kind of say, hey, you know, and maybe it's a good time to do it also because we got this going on, and, you know, just want to make sure, because there is time to change it, that you really understand the implications of this. You know, the other bar has a seat, there's public space, they didn't come and coordinate with us, there's a history, what does that mean? You know, we definitely want to work with the other bar. What would be the best way to do that versus you're funding this amount of money with absolutely no oversight or.
One sentence might be able to fix.
Well, I'd say it's, if it
Yeah.
hasn't gone out of the Assembly, there is still time to amend the legislation, both in approps and in the Senate. So, and then obviously the governor has his, you know, option to veto or pass that legislation. So,
Well, yeah, it's, I mean, and this again is included in the State Board's annual licensing fee bill, so this is not a bill that we're interested in seeing a veto on.
no, I wasn't saying, I was just saying that's
the process.
Technically,
Yes,
that's the
yes,
process.
absolutely right, yes.
Yeah, so, I mean, if you say there's no oversight, then that's vocal, but what I am guessing if I were on their side, I'd say, okay, we'll throw a line in there that says, we're gonna earmark the funds for this. There you go, oversight.
Mhm.
So when you say there's time, 'cause this is my naivete, when you say there's time to edit, there's not time to like bring it out of the legislation and still move forward to get the core of it passed?
What was the question?
So when Judge Rowland, you say there's still time to edit it, so if,
I'm saying that it hasn't been, the final approval hasn't been given by the Assembly. The Assembly is still going through committees. So it doesn't sound as though it's gone to the floor for a vote by all of the members of the Assembly as to whether they approve it. And for that reason, there is still time to address one aspect of it. Certainly, you're right, you don't want to see the fee bill die. So, not for this reason or for really any reason, but to raise this as an issue that could be tweaked or corrected, there's still time to do that. Because only after it finishes going through all the committees will there be the vote on the Assembly floor. With the vote on the Assembly floor, though, then it passes on to the Senate. So there's still some time. I don't have the.
You gotta hire a lobbyist.
The bar has a lobbyist.
Well, this committee need to, this
Yeah, how can we talk to the lobbyist?
Well, that's funny, that has been brought to my attention.
So are there concrete steps that we have established as far as attempting to get the attention of the board and the legislature our belief that this is an unwise allocation of dollars?
So the board needs to make the call on whether whether to bring that to the attention of the legislature. Right now, the board is taking a support position on this piece of legislation. It would expect that its committees, commissions, and sub-entities would not sort of be speaking in an inconsistent way with what the board has publicly communicated its position on the bill is. So it's more a question of communicating to the board the concern of the committee and seeing if the board is in a position to reconsider.
I think at the very least, they should rescind their support.
Say that again?
I think at the very least, they need to rescind their support.
And this is certainly a position that I can most certainly communicate through the group that takes the positions, that makes recommendations on positions to the board. I can communicate this as well directly to the chair of the board. I do think, I think it is unlikely that the board would change their position, and I don't want to leave you with a different impression.
Wasn't our whole May meeting about holding on to our reserves until like 2020?
They didn't agree to that.
Yeah, so they would
Stuart,
join.
do you think it might, just from the standpoint of our understanding things, to reach out to Larry Terry? And because I'm willing to bet you that he knows a lot about what's going on.
I could do that. I mean,
just from an informational standpoint for
But
us.
I would also just want to communicate to the board that this is unsatisfying to the members of this committee
Certainly.
in the strongest possible terms.
Yeah, no, and I can absolutely carry that message.
all right. Any other comments before adjournment at 12 o'clock?
Well, my only comment, as I always say, is that thank you very much for inviting Judge Rowland and me as invited members of this committee. Judge Rowland will be the new supervising judge of the hearing department next year, and so she'll be working. She's a hearing department working, boots on the ground with these issues with people that come before her, and so thank you for coming, Judge Rowland, and thank you for having us.
Oh, thank you very much. For everyone, for all the volunteers who spent some time with us, it's well received by all of us.
We thank you. I mean, for you to come and give your input, and I mean, you help bring a perspective that we don't have and gives us extra information, and we very much value, I know I value, I'll speak for myself, I very much value both of you, and when there's been other judges, and yes, so thank you.
Thank you for inviting us.
So with that, do I hear a motion to adjourn?
So moved. I second.
Second. All in favor, say aye.
Aye.
The meeting is adjourned. Go Dodgers.